Heather Cash.
Good morning, Judge.
Good morning.
We have that plea for your consideration in that case this morning.
Okay. I don't have it before me. Oh, wait, let's see. Yes, it is. All right, this is a negotiated plea. Counsel, come up. Thank you.
Would you like us to sit at the table or stand?
Table's fine. I think that mic is on. Not, I know it's on at the podium. All right. State, go ahead.
Yes, Judge. Ms. Cash is pleading to one count of reckless driving. The state has tendered a null pros to the court on the distracted driving and failure to use turn signal counts. I've amended count 1 in Odyssey already. And Judge, pursuant to a negotiated plea, we've agreed on a sentence of 12 months to serve 24 hours, credit for time served of 1 day with the balance on probation, for Ms. Cash to pay a $300 fine, complete 40 hours of community service, risk reduction, and alcohol and drug evaluation and any treatment deemed necessary, as well as a victim impact panel. Judge, we did agree that it could terminate upon successful completion of all conditions. Counsel, do you stipulate to a factual basis, venue, and identification for purposes of the plea?
Yes, I think.
Nothing further from the state, Judge.
All right, thank you. And is it Mr. Bernstein?
Yes, Judge. Good morning.
All right, is that your understanding of the plea terms?
That's correct, Judge.
All right, I will go through the plea statement to make sure that the defendant understands what she's doing, as well as making sure the plea is free and voluntary. And Ms. Cash, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
I guess I should have had you do that. Thank you. You can put your hand down. Normally I have the deputy do it, and I just did it really quickly. All right. It is my understanding that you wish to plead guilty to one count of reckless driving. Is that correct?
Yes, ma'am.
All right. And I'm going to ask you a few questions to make sure you understand. The first is, are you currently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No, Judge.
All right. Are you satisfied with the services and representation of your attorney?
Yes, Judge.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Judge.
Giving up and waiving the right to remain silent and not testify against yourself?
Yes, Judge.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you receive a lesser sentence for pleading guilty today?
No.
Has anyone promised you anything to plead guilty today?
No.
And do you understand that if you're currently on probation, your probation could be affected by your guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
So as to the charge of reckless driving, how do you plead?
Guilty.
All right, you've heard the conditions and understand. And it looks like that after you've completed all your conditions, you will go non-reporting or be terminated. Terminated. All right. I will accept your guilty plea. And I will sign. Any questions?
No, ma'am.
Sign the null clause. All right. If no other concerns, that will complete your plea and you're free to go.
Thank you.
All right, you're
Will
welcome.
probation meet with her today, or does she need to fill out the?
Are we still doing the QR code? What are we doing now? Oh, okay. Thank you.
And then somebody will sign. Okay.
Well, if they haven't contacted you, we ask that you go to the report.
Okay.
Okay, so if you fill this out, this.
Okay.
But intake, always you can take.
Okay.
Do
Do I just take this piece of paper?
Fill it out, give me this information and I'll give you a copy.
Here, have one. There. Bring someone else. Well, I understand. Thank you. Appreciate it. Last time for a while.
Next case I have is 21 CR 00306O Domingo Jarquin.
Good morning, Judge Maria Diaz from the Sonota Law Firm. My client is here. ¿Sí puede levantarse?
Good morning, Your Honor. I'm the Spanish interpreter for you this morning for this case.
Good morning, Miss Lucia. You're following me around, I see.
Yes, ma'am.
All right, come on up, sir, if you're the defendant.
Acérquese con su abogada, por favor, señor.
All right, State, go ahead.
Yes, Judge. So the state filed a motion for continuance in this case on which it would like to be heard this morning. I don't know if you want to go ahead and take the other pleas that are available, but we definitely want to be heard on that motion this morning.
Okay, let's hold for a second. I'll do the pleas first and then we'll
Okay.
do the
Regresa
motion.
donde estábamos. Vamos a regresar.
Regrese a donde estábamos, entonces, ahorita vamos.
Okay, hold for a second, Miss Lucia. Next case I have 21 CR 00645 Marcus Lee Maxey.
Good morning, Judge Jacobs, on behalf of Mr. Max.
Okay,
Yes, Judge. Defense counsel has filed a plea in bar in this case this morning that will need to be heard, Judge.
all right. Have a hearing shortly. Please hold for a second. Next case 21 CR 00286 Allison Saylor.
Yes, Judge, we have a plea for your consideration this morning. I believe all paperwork has been submitted to the court.
All right, counsel and defendant, come on up. All right, this is a negotiated plea.
Yes, Judge. And Your Honor, Ms. Saylor is pleading to one count of reckless conduct. I believe she is pleading under the First Offender Act, Judge, and pursuant to a negotiated plea, the recommended sentence is 12 months on probation to pay a $750 fine, complete 80 hours of community service, complete an animalcourts.com online course, as well as provide proof of restitution for medical expenses to Adam Quillian. Judge, Attorney Ryan did provide me with that documentation. I've also spoke with Mr. Killian, I believe it's pronounced, and confirmed that all expenses have been covered. With respect to this particular plea, we did agree to termination upon successful completion of all conditions. And finally, counsel, do you stipulate to a factual basis, venue, and identification for purposes of the plea?
Yes, we stipulate to all those.
Nothing further from the state judge, and I did hinder a null pros on the count two.
Just sign the no pros, okay?
Restitution, we need to know. They're gonna pay it to.
Oh, State, we do need to know the amount. It says provided to ASG. We have to include that on our sheet as far as restitution.
Can I send over the documentation and then print it out to be included in the plea or
See what,
paperwork?
That's fine,
It's
as
just-
long
yeah.
as the amount was there and who she's to pay it to, she's gonna pay it through probation or she's gonna pay it directly to the victim.
So it's already been covered and paid and taken care of by insurance.
Okay,
Yeah.
so there is no restitution.
No, just the proof of such
Okay.
was what was included.
14,500, but it's already been paid quite some time ago.
Yeah.
Okay.
okay, so then this plea sheet, okay, does say proof of restitution to Adam Quinlan provided to the ASG. Should we say that it's been paid via insurance to be very clear so that they don't think that she's gonna be on here?
Right, to pay that, yes.
Smith.
Nothing to pay.
Okay. Who filled out the on the plea sheet, it could be a little confusing because it says proof of, Ms. Smith, give this to council. Under there, if you can squeeze in there neatly, paid, completed, I'm thinking of a word. Paid by insurance.
That's fine.
Yes. All right. So we'll know that that has been completed. All right, Deputy, I'll let you do me swear in Miss Saylor. Oh, the deputy's changed. I saw that, but I didn't see that. Good morning. All right.
Yes, ma'am.
All right, thank you. All right, I'm gonna go through the same questions to make sure you understand what you're pleading to and that it is free and voluntary. First question I need to ask is, are you presently under the influence of any non-prescribed medication, drugs, or alcohol that would impair your understanding of your plea today?
No, Judge.
All right, and I understand that you wish to plead guilty to one count of reckless conduct?
Yes.
Okay, and are you satisfied with the services and representation of your attorney?
Yes.
And you do understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
You're giving up and waiving the right to remain silent and not testify against yourself.
Yes.
And you also are prepared and agree to waive these rights today. Is that correct?
Yes, ma'am.
And you also have not been told that you would receive a lesser sentence for pleading guilty. Is that correct?
Correct.
Has anyone promised you anything to plead guilty?
No.
And that you do understand that if you are currently on probation for some other charge, this plea could affect that probation?
Yes.
And you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And you've been explained the conditions of the other conditions that you have to complete, even though the restitution has already been paid and you're clear with those conditions. Is that correct?
Yes.
And it will terminate upon, probation will terminate upon completion?
Yes.
Okay. All right, I will accept your guilty plea. I have one more sheet that I need to sign. All right, I will accept your plea and I think since
Your Honor.
the $750 fine plus the balance probated. All right. Yes. Ooh, thank you. She did put the first offender on there, making sure. Okay. So I will accept your plea on the first offender.
Thank you, Judge.
All right. And does that complete everything?
That is just, we'll fill out the probation sheet.
Yes, do that sitting in the galley, and then once you finish, kind of bring it back up, get our attention. All right, thank you. Thank you. Next case I have is Quintavious Sims, 20 CR 005106F.
Yes, Your Honor, we've reached a negotiated resolution in this case.
Good morning, Judge Mincy.
Good
Sarah
morning.
Rosenhuber for Mr. Sims.
Hello, how are you?
Good. How are you doing?
Seeing you in person.
I know. Good to see you,
You
Judge.
too. All right. Oh, it says on here, Miss Helen, so I could see either of you. All right, we can swear in Mr. Sims. And what do we have, State?
Thank you, Your Honor. For position 5 on today's calendar, there were 2 counts. Count 1, carrying concealed weapon, and count 2, theft of services. The state has tendered a no pros for the carrying concealed weapon charge. And we have been able to resolve the theft of services with a plea. That will be 12 months probation, 1 theft course, and early termination upon completion of that theft course. Pursuant to that plea, the state has also agreed to no pros position 6 on today's calendar, which is 1 count of obstruction of law enforcement officer. Does the defense stipulate to factual basis, venue, and identification for purposes of the plea?
Yes, we do.
Nothing further from the state.
All right. All right, Mr. Sims. Now that you've been sworn in, I'm going to ask you a series of questions to make sure you understand what you're pleading guilty to, and that plea is free and voluntary, okay? All right, and so let me ask you first, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding of the plea today?
No, ma'am.
Okay, are you satisfied with the services of your attorney?
Ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up and waiving the right to remain silent and not testify against yourself? And I didn't hear you.
Yes, ma'am.
Okay, can't nod our heads. We have a court reporter on that is taking everything down. Also, do you understand and agree to waive these rights today?
Yes, ma'am.
All right, and has anyone promised you anything to plead guilty today?
Yes, ma'am.
No one's.
No, ma'am.
Okay, has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
All right, do you understand that if you're currently on probation, your probation could be affected by your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the free understanding of the charge against you?
Yes, ma'am.
And so as to the charge of theft of services, how do you plead?
Guilty.
Okay, all right. I will sign off, and I have one more to sign.
And fill out this document, and they're gonna tell you where to go to probation. If you go into probation and you already have a certificate of completion of that course, then you won't have to do anything else, okay? And you can finish filling it out in the galleries. Okay?
All right, I have signed everything. Ready to go.
Thank you, Judge.
All right, thank you. Next, I have 21 CR 000-520E Tyler, is it Sullivan maybe?
Yes, Your Honor, I think that's the correct pronunciation. This case is in the diversion program. All the paperwork has been completed. It just needs to be reset for a compliance date, but I don't know that we can be able to do that in this courtroom.
I think not.
So it would just be returned to the division,
Turn to division, further notice.
but not for a jury trial, just for a compliance.
Oh, well, that court date for compliance then.
Yeah.
And of course, I don't know what that'll be.
Neither do
All
I.
right. I know, we'll move to the next one. Jasmine Thompson, 20 CR 003290E.
Yes, Your Honor, the defense did file a conflict letter into this case, so I don't expect to be going forward.
All right, and that one I'm sure will be returned to the division. And I have 21 CR 005657B. Cynthia, is it Ukago maybe? Chicago, okay, thank you. You Attorney Mosley? Okay.
Good morning.
Yes, and this is a plea.
Okay. Swear to it, and I defended
Please,
you.
you swear and affirm that the testimony you given today in these matters are the truth, the whole truth, and nothing but the truth, so help you.
Yes, sir.
State your name for the record.
Cynthia Yukago.
Okay, Thank you. All right, State.
Yep, thank you, Your Honor. We have reached a negotiated resolution in this case. Count one DUI less safe will be no prost. The defense has agreed to plead guilty to the count two, fleeing and eluding. The conditions for that will be 12 months probation, served 10 days, credit for time served 2 days, balance probated, and a $500 fine. And the state will be no crossing count three, illegal stop. I do understand there will be some 2-for-1s given on time, so that will have to be addressed once we take the plea. But does the defense stipulate to factual basis, venue, and identification for purposes of this plea?
Yes.
Nothing further from the state, Your Honor.
Okay. Don't have the no pros.
Oh, I'll send that now.
Okay. And that's your understanding, Mr. Mosley?
Yes, that is.
Okay, I'll sign that no pros in a second. And, Miss, is it Ucago? Trying to get it, sorry about that if I
No, you're
didn't.
fine.
All right, I'll ask you a series of questions and make sure you understand and that your plea is free and voluntary. Tell me this, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No.
Are you satisfied with the services of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you would receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you understand that if you're currently on probation, that probation could be affected by the guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of fleeing or attempting to elude police, how do you plead?
Guilty.
All right, and understand your conditions, correct?
Yes, ma'am.
Okay, if there's no questions about that, I've got one more sheet to sign. Oh, we do need to know what day you'll be reporting for your confinement. Do we
This
have a date
Friday.
yet or?
This
kinda leave it
Friday.
up to them? Friday? Meaning tomorrow?
Day after.
I mean Wednesday, today's I was gonna say Wednesday, today's Wednesday, day after tomorrow.
Yes, ma'am.
Okay.
Your Honor, I am so sorry to interrupt. I am needed at Judge Roth's chamber. So would you like me to keep waiting for you or should I come back to you? He says that he has 2 pleas.
Yes, 2, please. They should go as quick as mine, hopefully. That's a motion for continuance You want to run there and come back?
Yeah, I can do
Okay.
that.
Okay,
All right, Your Honor.
thank you.
Uh-huh.
Okay.
That's right. Thank you.
For probation, just to be clear, balance probated, so she will not, after her confinement, she will not be on probation, or she will until she pays the fine. What was your agreement about probation after she finishes her
We
confinement?
didn't talk about it, Your Honor, but I'll be happy to do non-reporting.
Okay. Because I think the only thing after that will be her fine,
That's
correct?
correct.
So after the fine is paid, after confinement, then she will go non-reporting.
Okay.
All right, I have signed all the paperwork. Get back the beautiful paper clips. Okay. All right, and your plea is accepted and you're free to go.
Thank you.
Oh, you've completed the probation sheet. I forgot about that. You
Will
can
do.
sit in the galley and complete that, and then we'll take that back from you.
Thank you.
Thank you. And then I have the one other, is there one more plea? I'm Melissa Wilson or no?
Judge, that's not going to be a plea, but Ms. Wilson is present and would like to be heard very briefly about that, regarding the diversion conditions.
Okay, this is 21 CR 005979E, Melissa Wilson. All right, state, what do we have?
Well,
Or should I say defense?
I'll let the defense go ahead.
Okay,
sure, Judge, so
As the court may be aware, I'm sort of stepping into this case, handling it for Miss Helen, but I have had an opportunity to speak with Miss Wilson about the history of this case. I believe that it was officially referred to diversion on July 25th, even though the state offered it to her back in June. And then diversion reached out a month after the diversion paperwork was submitted. In that time, Miss Wilson already availed herself to pay for $250 worth of anger management. She completed 59 total hours of community service. She has completed those terms. However, it was an original requirement that she pay this $250 fee. Ms. Wilson, ultimately, Judge, due to a lack of communication, it's my understanding that perhaps Ms. Wilson and Ms. Helen had a different understanding about the terms. I wasn't a part of those conversations, but Ms. Wilson may want to address that. We've asked diversion to go ahead and just sign or submit a null pros for this case, and she has completed an additional 19 hours beyond what her requirements were. And diversion has requested that she either pay the $250 fee or complete an additional 19 hours of community service. So Judge, rather than send this back to the division, I know the court is limited in what Your Honor can do, but Ms. Wilson did want to be heard and for all of that to be on the record.
Okay. State, do you have a response?
Yes, Your Honor. I mean, I tend to agree to what the defense is saying. This case was referred to the diversion program sometime after the June trial calendar. There were conditions that were agreed upon. However, on August 29th, 2024, Catrice Helen emailed my office saying that Miss Wilson would like to no longer participate in diversion and was requesting a jury trial. And then after that, it became known to us that she already had completed some of the conditions of the diversion program, but not exactly the ones that were prescribed in the agreement. Our diversion program is very strict on the $250 intake fee. There is an opportunity to waive that fee for an additional 19 hours of community service, but that is something that needs to be agreed upon at the time of intake, not later in this process. And so the diversion program, which is out of my control, has asked Ms. Wilson to either pay the $250 fee or complete an additional 19 hours of community service and then exchange for a null pros. And so that's the posture that we're in today.
And so originally she was to complete 40 hours of community service?
That's correct, Judge.
Yes, Your Honor.
And she did the extra 19, but not under the pre-arranged agreement that she would do the 19.
Yes.
Okay. And is there anything else, Ms. Wilson? I think you want to be heard to speak for yourself.
Yes, Your Honor.
Okay, go ahead.
In this case, we have been, the miscommunication, I believe because Ms. Helen was overworked. And by the time she gotten back with me, which is quite some time, and they've already given you those dates from June the 11th until when I heard something back was August 29th. This would have given me 2 business days, which was Thursday when they gave the email. I was under no notification that I would be hearing from the diversion program to even look for an email. So on Friday, that's Friday, that's 1 business day. Monday was a holiday. On Tuesday, I paid the $250, which is what I was under the impression I would need to pay. And I started the anger management courses. So pertaining to what the courts asked for me to do, I was under the impression that I had done what I was supposed to. So on the new calendar date for September the 4th, when I came in, the only requirement left was to complete the anger management programs. Richard reached out to diversion to see how many Richard is the program director at anger management. He reached out to see how many classes I was required to complete because at that time there was still no paperwork pertaining to the original assignment, which was the 40 hours and the anger management. So he still hadn't heard anything back up to today. And he did send in the letter of completion for those classes. The $250 that I paid I was under the impression that these $250 is what was required of the court. Because I had no documentation, my lawyer had no documentation, and they had not responded back in the amount of time needed to make sure these things were done. So here recently, I've given all the information that I needed to give to Ms. Rosenberger so that she has everything that's needed to present to the courts today.
So the $250 paid was for anger management, not the intake fee.
Correct.
Is that correct?
It is, Judge. That's correct.
We didn't have that information at the moment.
Yeah, when you initially signed up for diversion, there was no paperwork and you were not told at that time that there was a $250 intake fee as well?
What I talked to Miss Helen and she told me I have to pay $250. She didn't specify where. So when I went to the anger management, this is where I paid the complete $250 in one payment. I also forwarded that information over to Ms. Rosenberger. Am I saying your name right? I'm sorry.
Don't worry about it.
I did forward the information over to her because that is what I believed without paperwork needed to be done. I've gone above and beyond to make sure that I complete the parameters of the courts, and this other fee was something that I did not know about.
Right, I guess I'm very concerned about the paperwork because we're usually very, very strict on making sure we have that so that, again, you have documentation, we have it as well. But the $250 that you paid, I believe it sounds like that was for the anger management courses, not for the intake. They should have gotten the intake fee, which they normally do initially before she would start on the courses generally. And I'm not there, so I don't know exactly how they do it.
My understanding, Judge, is it was when Ms. Wilson accepted the terms of diversion, it was in the heat of a trial calendar where Ms. Helen came to her and was like, hey, will you do anger management and community service for diversion? And that was the extent of their conversation. And then Ms. Helen perhaps did not reach out to her after that, and Ms. Helen signed on Ms. Wilson's behalf. Ms. Wilson didn't get a copy of that diversion paperwork until much, much later. So while the paperwork does reflect that the $250 was required, it's Ms. Wilson's contention that she was not aware of where that money was going. And again, I wasn't there, Judge, but.
And they'll probably be mad at me if I say they don't get their fees and then the program is closed. You know, so again, you have these government agencies that administer these programs and diversion that have fees that need to be paid. And you can imagine as a judge that I always hear, I didn't understand, or I didn't know, or my lawyer didn't tell me. You know, I hear that a whole lot. I am sympathetic to that. And it's somewhat problematic because the program has to run and they charge that fee to administer the program. You have completed the other 19 hours or the additional 19 hours, which is what they require in lieu of the fee. And you just need me to say it's okay since we're accepting that in lieu of the fee. And then sign an OPROS for your case. And I certainly don't want to add any more angst or anxiety to the situation. So it appears to me, although it was not clear at the beginning, and you did the extra 19 hours, that I would sign some type of order to say that the 19 hours have been completed in lieu of the payment of the $250, and I will accept that, you know, for the no pros, okay?
Yes, ma'am.
And so whoever gets me will get me at some point for that, hopefully not, but can someone prepare me an order for that?
Do you want me to do it? Okay. Yes, Judge, I'll submit an order.
Okay, send it to Ms. Smith by Friday. Ms. Smith, where will you be after that?
I'll still be here until the 30th.
Until the 30th, yes. We got to get on that because, you know, ORCA
Absolutely.
will be over on the 30th.
Absolutely.
yeah.
I'll get it to you today.
Yeah.
Okay.
All right, thank you.
All right,
Judge.
thank you. Good luck to you.
Thank you, Your
All
Honor.
right, you're welcome.
And Judge, that concludes my business, if I may
Okay.
be excused. Thank you.
All right, thank you. I keep forgetting it's the end of the month. And the last case I have is Antonio Lester. 20 CR 0048884G. Is Attorney Richardson?
Yes, Your Honor, good morning.
Good morning, how are you?
Good, thank you.
And state, what are we doing with this case today?
The state will be tendering a null pros into this case
Oh, okay.
for both counts.
For both counts?
Yes, so I'll
Short
get
and
that to
sweet.
you momentarily.
Thank
Okay,
you.
all right, I'll sign that shortly.
Okay, and say shortly,
They're gonna send it over real quick and she's gonna print it and I'll sign it.
I'm just wondering if it's something I can wait for or
Yes, actually you can and she'll give you a copy.
I will. Thank you. Your Honor.
Okay, thank you. You too. So we'll go back to our motions. Let me see something. Hold on. Mr. Emden. I saw you sitting there. I won't put you to work, but something must have happened. The seat blew up and it was horrible. So I don't know. And was that what he's going to do? Just remember. I don't know. Who was in here yesterday? Was somebody in here yesterday? Blame it on men, but if he's going to use it, it's too. But I forgot about this one. Isn't there one on the side here? I think Chanel went. Yeah, I think she went to use that one when we were here last because that one was horrible. So I don't know if it's getting messed up in between. And I said, Taki must not be looking at his emails. Mhm. Oh, yeah, the net, yes.
I'm gonna meet you, Judge Mincy, just to let you know. Judge, don't forget to unmute.
Ooh, I'm so sorry. Let me call that case again. This is 21 CR 006451G State versus Marcus Lee Maxey, Maxie, charged with one count of DUI less safe, second count driving while license suspended, offense date April 24th, 2020. And this is a plea and bar motion filed by defense, correct?
Yes,
Okay, so defense, you may go first.
Judge, our arguments are basically going to stem solely from the record and from argument. So we don't really have any witnesses from our perspective, but I know that the solicitor indicated that she had a witness she wished to call, so it may be more appropriate to let them call their witness and then proceed to argument.
Okay, State, do you have a witness?
I do, Judge. I would just ask that defense kind of put on the record.
What he's asking for.
What's being challenged and all of that.
Yes, Judge, I'm happy to set the record. That's no problem.
Okay.
Judge, basically in brief, Mr. Maxey was arrested on April 24th, 2020 in Johns Creek. He was charged with DUI and suspended license. That case was bound over to State Court of Fulton County on May 25th of 21. November 16th of 21, an accusation was filed, charging him with the DUI and the driving on suspended license. On February 15th of 22, defendant filed a waiver of arraignment and a demand for jury trial. On January 23rd of 2023, and this is, I think, where one of the things that I disagree with there, it appears from the record that a second accusation was filed. It is stamped on that day. It is stamped in. Then we'll get to that argument, but that's from the record that appears to be what happened. I think the state disagrees with exactly how that got framed, but on that subsequent indictment, there was never an arraignment, and then this case was transferred to the ORCA calendar. I don't know the exact date of the transfer, but I know that we were set for a status conference on May 1st of 2024. And it was set over, I think in open court, we were set over to August, but when the actual calendar came down, we were set over to this day for motions, and we filed our plea and bar prior to the motions date, Judge. And so really there's two things that we're arguing about. One is this sort of double accusation issue, and the other is a constitutional speedy issue.
All right. State.
And Judge, just before I call Mr. Emden to the stand, they've asserted a violation of the defendant's right to a constitutional speedy that I will deal with later. I think that will require only argument. So with respect to the accusation issue and what is being alleged by defense, correct. So the accusations in this case were entered on November 16th of 2021. And when I put Mr. Emden on the stand, I will go through the record with him in Odyssey so that the court can see that. On January 23rd of 2023, there were accusations that did not have the accusation number and did not have any other file stamping on them that were filed. Yes, it is our assertion that they were filed as part of discovery. And when I go through the record with Mr. Emden, it will show that in Odyssey, it is labeled as discovery. And so those accusations were inadvertently stamped, yes, with a date of January 23rd, 2023. But it is our contention and argument that that is not the actual accusation it had in this case. And so the accusation has not been amended to that date. The accusation has not been filed on that date. It was previously filed on November 16th of 2021. And the accusation that you see in Odyssey's file stamped as January 23rd, 2023 is simply what was filed as part of the discovery, and it got a file stamp as a result of being included in discovery. Those accusations, in our opinion, do not supersede the original accusation that had the accusation number that was file stamped on November 16th of 2021. Furthermore, Judge, just as argument, even if you were to, I think he also asserts that the January 23rd, 2023 accusations, that those are missing tolling language and are therefore insufficient from what I read of his motion, of his plea in bar. And so even if you were to find that they were somehow actual accusations that were filed and with the intent of superseding or amending the original accusations that were filed in November of 2021, tolling language is not required to be included. I'll cite the Garrison case and I'll provide the site for that. And so with that, Judge, I will go ahead and call to the stand the state's sole witness for purposes of this motion hearing, which is Mr. Nataki Endon with the Fulton County State Court Clerk's Office. I don't know where you want him, if you want him seated there or.
I guess, well, let's come over here. We'll do the regular witness one. And I want to just make this one statement for the record, and I apologize. I did not know why he was here. I actually, certainly us judges lean on him because of his position in the clerk's office. So I don't want it to appear that I was certainly talking to the witness. We were talking about clerk stuff and judge stuff. And I just assumed he was here watching me. So I apologize. I did not realize he was a witness in your case.
I understand.
Okay.
You swear and affirm that the testimony given today and you have to hold to the net for the truth, so that you
I do.
state your name for the record.
Nataki Emden, Chief Deputy Clerk of the Criminal Division in State Court.
Yes.
And Mr. Glanville, would you mind making me a host so that I can share my screen, please?
It's been done.
Thank you. Okay, Mr. Emden. Can you state your name for the record, please?
Nataki Emden,
And spell your name, please.
first name Nataki, last name Embden.
And where is it that you currently work?
In the State Court of Fulton County Criminal Division
Okay. And how long have you been with the State Court of Fulton County Criminal Division?
since 2021, I believe, July.
And can you tell the court what it is that you do in your capacity working with the State Court Clerk Criminal Division in Fulton County?
I'm responsible for organizing the criminal division, making sure the filings come in correctly, modifying the system as needed to ensure the court process goes correctly and optimally.
Okay, and specifically, what is your title?
Chief Deputy Clerk.
And where did you work prior to Fulton County before 2021 when you came here?
Before State Court, I worked as an Assistant Chief Deputy Clerk in the Clerk of Superior and Magistrate Courts. And I've been working there since 1999.
Okay, and was that also in Fulton County?
It was.
Okay, all right. And did you work there in a similar capacity, doing the same duties and responsibilities that you just talked about?
Within the criminal division, yes.
Okay. As part of your duties in the criminal division of State Court, are you familiar with Odyssey?
I am, very.
Yes.
Yes.
Okay. What is Odyssey? Can you tell the court?
Odyssey is the unified case management system within courts in Fulton County, shared by the prosecutors, the clerks, and the public defender.
And is your familiarity with Odyssey based on your use of it in your capacity as the clerk?
Yes, I was involved in the original configuration when Odyssey was brought online in 2015.
Okay, so you helped to create it, is that correct?
Yes,
Okay, and so you've been trained on the use of it as well?
I have.
Okay, can you tell the court about that training?
I was part of the team that worked with Tyler when they're beginning the configuration. I've also attended classes and seminars as well as the conferences by the software developer Tyler Technologies as new features and advances in Odyssey have rolled out.
And I heard you say it was implemented in 2015, so it's been around for approximately 9 years, is that correct?
That's correct.
Okay. And you've been using it the entire time?
That's correct.
Okay. I want to turn your attention to the Odyssey record in this case. Is the official record for the court on a particular matter, is that correct?
It's the case summary, yes.
Okay. I want you to identify what is the first entry that you see. That
is the accusation entered in November of 20. The font is very small. I believe it's 2020.
No, I don't have any way of making it bigger. You're certainly welcome to come up to the screen if need be.
Yes, that's November 16, 2021, the accusation entered OBTS entry.
Okay. And when one clicks on the icon that is located next to that entry, do you know what it is that would appear?
It should be the accusation, the initial charging document for the case.
Okay, and before we proceed, just one more question. Have you had an opportunity to look at this record and review it prior to today?
I've looked at it briefly, I think yesterday, and I've probably seen it before at some point.
Okay, all right. So if I were to click on this, you're saying that the accusations would come up, is that correct?
It should. I normally don't enter it from the case summary side, but yes.
Okay, and is that just a double tap?
Yes, double left click.
Okay, all right. And so when I double tapped on that, what is it that then comes up?
November 16, 2021, there are two scanned images with redaction. Normally, there would be a single charge that was filed on by this prosecutor. So those should be two separate charges.
Okay, so each of these, I guess, icons would be accusations for two separate charges, is that correct?
Yes.
Okay. And I'm going to click on the first one. And Judge, I'm going to ask that the court bear with me. Technologically, I am not as advanced. I'm going to now have to stop sharing the other screen and share another one. Thank you. Okay. Mr. Emden, can you tell the court what it is that we're looking at that popped up when I double clicked on that first icon?
That should be the initial accusation. It appears to be charge number 2. It's got the initial file stamp where it was entered in the top right. Defendant case style across the top, the initial charging information in the middle, and then the signature of the solicitor, Mr. Keith Gamage, on the lower right.
Okay. And can you tell the court what date is showing as this being filed in?
That is the date when the clerk accepted it from the solicitor of November 16, 2021.
Okay. And can you tell the court the case number that is showing, that was first of all, that number after accusation number that you see that begins with 21 CR, is that assigned by your office?
The clerk's office along with Odyssey, yes.
Okay. And can you tell the court what that number is?
It's 21 CR 006451G.
And I heard you say that this, that date is when it would have been received from the solicitor's office, correct? That date of November 16th?
That's correct.
Okay, and when it is transmitted or sent from solicitor's office to your office, does your office do anything to modify, alter, make any deletions or additions to this document, or do you file it as it is sent from the solicitor's office?
The only additions that we add are the file stamp and the case number if needed.
Okay, so nothing in the way of additions, deletions, or alterations have been made to the body or text of the document, is that correct?
That's correct.
Okay. Judge, I don't know that I need to enter it into evidence, it's part of the record. So I would just ask that you take judicial notice of it.
Judge, it's part of the record. I'm not.
Yeah, we'll take judicial notice since it is part of the record.
So I
Correct.
won't bother to admit these accusations as
Right.
evidence or exhibits.
Okay.
Okay. Okay, we are back to Odyssey. And I'm just going to click on the second icon. I'm gonna get us back to where we were. Okay. And can you explain to the court what we are looking at and what popped up as a result of double clicking on that second icon that we saw?
This appears to be count one of the accusation number 21 CR 006451G. DUI, driving under the influence of drugs, less safe. It's got the file stamp on the top right, and solicitor Gamage signature on the lower right as the second count, similar to the second count.
Okay. And please tell the court the date that clerk's office would have received this from the solicitor's office.
Of in November 16, 2021.
Okay. And does there appear to be, other than that file stamp in the upper right-hand corner, any other alterations, deletions, modifications to the body or text of this document?
No.
Okay. And this is how it would have come over from the solicitor's office?
That's correct.
Okay. Judge, I'm going back to the Odyssey screen. And then I am going to come on down and ask you about the filing that is entered on January 23rd of 2023. Can you tell the court what that filing is for?
That is discovery, the subtext initial discovery.
And how is that sent to the clerk's office for them to put into Odyssey? Does that come from the solicitor's office as well?
It does, but it's sent through e-file Georgia.
Okay. And is that different from how the accusations we looked at earlier? Is that different how those are sent?
It is different, yes.
All right. Can you tell the court about the differences?
In order to initiate the case directly from the prosecutor through Odyssey, the charges have to be sent through the Odyssey system itself. In the case of state court, there is a queue that's set up where the charges and the charging document are sent from the solicitor to the clerk through Odyssey. Every subsequent pleading is usually sent through eFile Georgia, which is another Tyler product, which is actually they image it and send it through us, and another clerk, a different set of clerks would accept that through that system, which makes its way into Odyssey.
Okay, and so through Tyler, is it true that anyone can send something into the system as far as the filing, defense counsel, whoever?
That is correct.
Okay. I'm gonna double click on that label, the icon next to discovery. And what is it that comes up?
When you hover over, it says owner user file serve, which shows that it came through the Odyssey e-file system.
And do these icons lead to specific documents?
They should, yes.
Okay. I'm going to click on the first one. And so I clicked on that first one. And can you describe for the court what it is we are looking at?
This appears to be a copy of the charging document, the first count of the accusation.
Okay. And can you tell the court the date that was stamped through Tyler on this particular document? Or was there a date that was stamped in Tyler when it was sent?
So the date that's on the top right there
Yes.
is January 23rd, 2023.
Okay. And where would that date have come from?
From the clerk who accepted it in eFile Georgia.
Okay. And is eFile Georgia Tyler?
It is.
Okay.
It's a Tyler product.
And do you notice anything different from this accusation than the one for count one that I showed you just a minute ago?
This version does not have the accusation number.
And do you notice anything different in the body or the text of the accusation from the one before? And if I need to put them up side by side, I can do that.
Yeah, I would have to have them side by side to look at the
Okay.
differences in the body.
Let me see if I can do that. I think I know. Yeah, I do. Mhm. That's right. Okay. I don't know if it's gonna show up on the phone. Okay.
Stop sharing, try to.
All right. Give me one moment.
This. This. There's another one somewhere. Move this pen down.
Okay. If you can, Mr. Mden, I know you've already noted the distinction with regard to the stamp file date, file stamp date in the upper right-hand corner, as well as the actual accusation number. But can you compare them, read them side by side, and tell us whether or not there appears to be any difference?
From this, I don't note any other difference.
Okay. Um, when an accusation is amended or the text or body of the accusation is amended, what is the process on your end?
It is sent through the Odyssey queue. All charges, initial accusation or amended accusations are filed through the queue to the clerk's office.
Okay. And do those come, like the original accusation that we saw, do those come from the solicitor's office as well?
Yes, that's correct.
And when you guys receive it, what do you then do with it?
When we accept it in the queue, it works its way, it migrates into the case record once we accept it. And we'll amend the charge if it's an amended accusation. So there will be a indicator that the charge is amended.
That's what I wanted to get to. So what will it denote or say that indicates to you that this is an amended charge?
When it comes through the queue, then we can see the charge that it's a link to. Once we accept it, then once we make the amendment, then the charging tab in Odyssey will have a symbol denoting that it's been amended.
Okay. But when you receive it like this, is there typically something on it that will indicate to you that it's amended?
It will say amended from, and there'll usually be language on the bottom right where the Solicitor General section is.
Okay. And sometimes is there not the actual word amended in front of the accusation number? Have you seen that?
Sometimes that will appear as well.
Okay. Do you see either of those things on the accusation that is file stamped January 23rd of 2023?
I do not.
Okay. This one out. The same thing with count two.
Let's keep it the way it is.
Okay, appreciate it. Okay, actually, I'll need to go back because I got to click on the icon.
Okay.
So,
Well, it's just showing your whole screen, right?
okay,
So I think that's all right.
okay, all right, cool. So that the court can follow along. I'm now going to click on the second icon that comes up after I double clicked on discovery. Okay, so Mr. Talley, excuse me, Mr. Emden, I apologize. Same series of questions. Can you take a look at the accusation that popped up when I double clicked? After clicking on the discovery, and can you identify the file date for that, the file stamp date?
January 23rd, 2023.
And do you notice any other difference? Just off the top of looking at it between that accusation and the one that was file stamped November 16th of 2021.
Other than the missing accusation number, none.
Okay, and can you read both documents, compare them, and tell me whether or not there is any amendment to the text or body of the accusation? And I'll get it so that you can hopefully see both of them. Can you do that for me, please?
Yes. There's no difference between the text that I can see.
Okay, and the labels that you talked about when an accusation is amended, I think you said there will be something at the bottom that says amended from. And I think you also indicated in your testimony that there may be the word amended in front of the accusation number.
That's
Do you
correct.
see either of those on the accusation that was filed as part of discovery on January 23rd of 2023?
I do not see either of them.
Okay. Okay, I am going to go back to Odyssey. I'm going to click on Discovery one more time, and I'm going to click on this last icon. And I want you to just describe for me what comes up, and then I'll ask you some questions about it. Okay, when I clicked on that icon under Discovery, what is it that popped up?
In order to bind over, appears to be documents coming from Municipal Court of Johns Creek.
And I will continue. Scroll down. Can you tell me what other document came up that this is currently looking at?
It's the uniform traffic citation from City of Johns Creek Police Department for Marcus Maxey Lee.
Okay. And what about this? What does this appear to be?
Appears to be the incident report from the case.
Okay, for Marcus Maxey, is that correct?
Yes, that's correct.
And as I continue to scroll, what does this appear to be?
It's another part of the incident report.
Okay. Okay. You familiar with Discovery as it's received in your office pretty regularly, correct?
That's correct.
Okay, and does that typically consist of reports and citations and things like that?
Yes.
Knowledge?
Yes, underlying documents, reports that they wish to file into the case to be
Okay.
made public.
Okay. And if you're able, can you tell the court what date this discovery has been file stamped?
January 23rd, 2023.
All right. And that's all I have at this time for Mr. Henry.
Okay. Any cross-examination, counsel?
Yes, Judge, thank
Okay.
you. Just a few brief questions. Good morning, sir. How are you?
Good morning. I'm well. How are you?
Judge, it may be easiest if I can just approach. I don't have access to the document here.
That's fine.
Oh, it's just the printed copies. Thank you, Chair. So I'm handing you, these are the printed copies of what we were just reviewing on the share screen. Do they appear to be the same as what you were reviewing previously?
Yes, they do.
Thank you. And Judge, if I can stand here, because I need to point out some things. Thank you. You would agree that on neither copies of the accusations, there is no date on the signature line, correct?
That is correct.
The
On
only
solicitor signature line,
yeah,
yes.
the only dates we have are the actual file stamps themselves, correct?
And the incident date in the body, yes.
Yes. And when we were reviewing these earlier on the share screen, you would agree, if you recall, that the second set of accusations that were file stamped in January of 23, when we look at that, each page of the accusation was actually stamped separately from the 21 pages of discovery that was stamped apart from the accusation pages, correct?
That is correct.
Okay. And you would agree that in just looking at the face of these documents and the file stamps in these documents, there's no way to discern from the face of this document that this was a discovery only stamp or anything that would indicate this stamp was only for discovery purposes when looking at the document, correct?
With the documents given me, yes.
All right. And even though there is no case number on the line, the actual file stamp on the second document does contain a case number, correct?
It
On the
does.
second set.
It does.
If I can have those back for me, I think that's all I need. Thank you.
I just.
If you, Judge, I believe that's all I had. Thank you.
Okay.
Just briefly, he asked you about a second set that had a case number. Is that correct?
That's correct.
Okay. Can you identify for me which set that is? And since the body is the same as we've established, the text of it is the same, can you identify which one has the case number by the file date in the upper right hand corner? Which set?
So the one in my right, which does not have the accusation number stamp, is the one that has the accusation number in the file stamp in the top right, because this is the e-file stamp.
But it does not have the actual accusation on the document.
That's correct.
Doesn't have the accusation number, you mean, on
In the body of the, in that top right, where there's a space for an accusation number, there's no accusation number placed in there because the e-file clerk wouldn't put it there.
And so would it be correct that this number, this accusation number in the upper right-hand corner refers back to the actual accusation that was filed with the same number that connects them?
It does. It's applied to the case. So it says that it goes to that case, the filing.
He asked you about a date on the signature line, and you said that there was not one.
That's correct.
You've received how many accusations in your office from hundreds, thousands?
The hundreds of
thousands?
thousands,
Hundreds of
hundreds of
thousands,
thousands, yeah.
Is there ever a date on the signature line?
No.
Okay. Nothing further from the state judge.
No, you're further, Judge.
Okay. And counsel, make sure I understand, in taking judicial notice, I have the set that was stamp filed for discovery, which is January the 23rd of 23, correct?
Yes.
And on that set, it has the accusation number above the date
Above the date, but not on the actual.
and not on the actual, right?
Yes.
And then the one from, the one from November 16th of 2021 has the accusation number in the line, to the right of the caption of the case, but not in the top, clerk stamp. Is that correct?
Correct, Judge.
Okay, just making sure I'm following as well.
Yes.
Okay. And that's basically the only difference. Okay, okay, make sure I understand. All right,
And nothing further from the state judge.
okay,
It's nothing further.
and nothing further. Okay. So you all are ready for your closing arguments, or I should say, first, let me say, if you finish with this witness, may he step down?
Yes, Judge.
Okay,
No objection.
May I have an
Okay.
excuse from the court, Your Honor?
I guess you may. You can go back to work now. All right, thank you.
I guess the next issue to take up would be, the constitutional speedy.
Mm-hmm,
It's defense motion, I'll allow defense to.
okay, go
And
first.
Judge, I think that can be argued strictly from the record. I think we don't need any witnesses on that.
Okay, any response from, the state on that?
No, Judge, I have no intention of calling it.
Okay. All right, if there's no other witnesses, no other evidence to be presented, we're ready for closing arguments or closing statements?
I think so, Judge.
Okay. All right, Mr. Stidman, do you want to go first or last?
Judge, may I reserve?
Okay,
Judge, you heard, testimony from Nataki Emden of the, State Court Clerk's Office Criminal Division. You heard him testify that he has, extensive experience with Odyssey, that, he was part of the implementation of it, since the very beginning, that he has been trained extensively on it. And my purpose for walking him through the, official court record was to show that the accusations in this case for count 1 DUI and count 2 driving on a suspended license were filed and entered into the court record in our system well within the statute of limitations. This case occurred on April 24th of 2020, and we filed our accusation on November 16th of 2021. So well within the 2 years that is required. The accusations that defense counsel asserts somehow supersede those accusations were file stamped with a January 23rd, 2023 date. But those accusations do not replace the accusations that were entered within the statute of limitations on November 16th of 2021, because those accusations were filed as part of discovery. Within Odyssey, the record showed and clearly labeled the accusations as entered on November 16, 2021, and later showed that entry from January 23rd of 2023 specifically labeled as discovery. That is what those accusations were entered as, discovery. And they were stamped with the January 23rd, 2023 date, just as the discovery packet was that contained the bind over document, the crash report, the incident report, and the uniform traffic citations. And so those accusations were not we compared the text of both the accusations from November as well as the ones from January. There was absolutely no difference other than the fact that the ones in January did not even have the accusation number as part of the accusation. And the accusation number that you saw in that upper right-hand corner, I asked Mr. Endem specifically, does that notate it back to that case? And he said that that just indicates the case that it's associated with. And so, Judge, it's my argument, it's the state's position that those accusations that were file stamped in January outside of the statute of limitations, they are not amended accusations, they are not superseding accusations, they were simply filed as part of discovery, and that the accusations on which the state would be proceeding at trial that must be filed within the statute of limitations are those that are entered into Odyssey on November 16th, 2021, when the solicitor's office accused this case and sent those accusations to the clerk's office. Even if somehow you were to find that these January 2023 accusations that were filed as part of discovery, as clearly labeled in Odyssey, somehow supersede those previous accusations, they are still they're still valid. The reason being that statute of limitations was told. So this case occurred on April 24th of 2020, which means the state had until April 23rd of 2022 to accuse it, 2 years. But as the court is well aware, the statute of limitations was told numerous times, and that gave the state an additional 1 year, 3 months, and 16 days in which to file accusations. And so, given that would take us onto August 9th of 2023 as the date by which we had to file accusations with the statute of limitations being told. Even that date of January 23rd, 2023 is well before August 9th of 2023, which would have been our deadline with that tolling. So I think what he complains of is this idea that there's no tolling language within the accusation. And I would argue to the court that it's not required. And in arguing that, I would rely on Garrison v. State. And Judge, this I think was just published today. And so I will provide the number that I have, which is 2024 Georgia Lexus 178. And I'll also provide another number, S24G 0007. And what the court held is that the state did not need to allege or prove the application of orders issued under the Judicial Emergency Act in order to rely on such orders to prolong the limitations period. And so therefore, the state was not required to allege and prove the tolling or extension of limitations arising from emergency orders during the COVID-19 pandemic, because the issuance of an order under that act rendered the order effective in every single case. And so we're not even required to allege it because we're simply not required to prove it. And that's if you were to take those January 2023 accusations and find that they somehow superseded the original accusations, which I'm arguing that they don't, but if you did. And so for that reason, Judge, I would argue, and I would first ask you to deny his plea and bar on that basis. The state has filed accusations in this case well within the statute of limitations. As you saw, they were filed on November 16th, 2021, well within the 2 years that we had to file them. And I would ask you to deny defense counsel's plea and bar on those grounds. Did you want me to go into the speedy argument, or you want to be heard on the limitations?
I understand that. Well, go ahead and do the speedy. I can take them both together.
With respect to the state's argument on the speedy the assertion of the, or allegation of a speedy violation. I'm going to go through first procedural history on this case. Because I want to point out just a few dates.
Okay.
So as I stated earlier, this case occurred on the incident date of April 24th of 2020. That is the date of the incident. I want to point out that that is at the height of COVID. I believe COVID occurred in March of 2020. And so the very next month was when this case occurred. And I believe everyone at that point in March of 2020 had started to be sent home, is what I recall. I recall my last day being around mid-March of 2020. This case was then bound over from the Johns Creek Municipal Court on May 25th of 2021. While that sounds like a long time for a bind over, I want to point out to the court that we're still in the middle of a pandemic at this point. And so that is why it took so long for Johns Creek to send us this case. Typically, it doesn't take a year, in a month, a year and some change. But in any event, we got the case on May 25th of 2021, was bound over to us. Defense counsel was the attorney at that time and bounded it over. We were still in the height of the pandemic. And on November 16th of 2021, as you heard, the state filed accusations in this case. So within 6 months of us getting that case, despite being in the height of the pandemic, our office managed to get this case accused. On February 16th, 2022, there was arraignment before Judge Mather of state court, where defense counsel waived their appearance and demanded, as we know, a jury trial. Now, on February 8th of 2023, this case appeared before Judge Mather, and what is notated in Odyssey is that it appeared for motion. However, there's no outcome that is noted. This case was then transferred to the ORCA division on December 21st of 2023. The order for that transfer was entered a couple of weeks earlier on December 5th, but it was actually transferred to us on December 21st, 2023. And on May 1st of 2024, within 6 months of that transfer, we had this case scheduled in ORCA on a status calendar to be heard. The next entry I see as far as court hearings and court dates is September 18th of 2024, which of course is today. So we got this case on a motions calendar within about, looks like about 4 or 5 months. So things really, started to move upon this case being transferred to ORCA. Your Honor, when considering a violation of a constitutional speedy, you are to consider those Barco-Wingo factors, which are the length of the delay, the reason for the delay, the assertion of the right, and any prejudice to the defendant. So I will go through those now. With regard to the length of the delay, that was the reason that I set forth the procedural history. So presumptively, a year or more is that is presumptively prejudicial, Judge. But what I would argue to the court is that, number one, the length of the delay is just one factor to be considered. And number two, it should not be held against either side, because that delay was due to a global pandemic, as we know. Something that could not have been foreseen, something that certainly was not caused by either side, and something that, neither side, would have wished to have occurred. And so I would ask that factor really not be attributed to either side. It's neither side's fault. The second reason, or the second factor rather, is the reason for the delay. And I think this reason is inextricably tied to the length of the delay, right? There was a global pandemic, okay, that cannot be attributed to either party. And jury trials were for a time halted. So there was no trial, no jury trial to give the defendant at least for a portion of that time. Now, with regard to other reasons for the delay, Judge, I would just point out that there are several entries within Odyssey in which defense counsel has filed leaves of absence. And so, of course, that affects the ability of the state to give defense counsel a jury trial. Not just the delay from the pandemic and the fact that jury trials were halted, but I show, Judge, approximately 8 leave of absences, and I'll go through them. There was one on June 16th of 2022, June 21st of 2022, December 22nd of 2022, on April 20th of 2023, on December 13th of 2023, on April 4th of 2024, and then yet again on July 17th of 2024, yet another leave of absence was filed. And I only point that out to show, Judge, that in addition to jury trials being halted and us not being able to provide a jury trial to defense, that also impacts it when leave of absences are filed and defense counsel is unavailable for any trial that could be scheduled. It has an impact. And so that reason for delay is, once again, but one factor, one out of the 4 to be considered. They're all, to be given weight. And I would ask that that particular factor, from the standpoint of the leave of absences and any delay that caused, be held against, obviously, the defendant. I would not ask that COVID be held against the defendant. The third factor, the assertion of the right to a speedy trial. We know that a constitutional speedy trial can be demanded at any time. But in this case, defense counsel has been the counsel of record on this case since it initiated in Johns Creek, where he bounded it over from. And so it was not until last month that defense counsel filed anything asserting this constitutional speedy, or even asserting that it had been violated. And so with regard to the assertion of this right, Judge, I would ask that that factor be held against defense. Because it wasn't brought up until 4+ years after this case initially found its way into the court system. 4 years and 5 months exactly after the initial arrest of the defendant. Finally, Judge, that last factor of prejudice, I don't believe there's any prejudice to the defendant in this case. I know for a fact that the officers in this case, Officer Hennessy, as well as Officer Okeson, are still around. They are still employed with Johns Creek Police Department. They are still available for trial. In fact, they were on call for today, should they have been needed, but they are still around. Officer Okeson's name has changed. I believe it's Briggs now. Don't quote me on that. I can get the correct name, but sent over subpoenas to Johns Creek. They were confirmed as still being there. And so there's no loss of evidence in terms of witnesses in this case. And even if there were, that would be to his benefit, certainly would not be prejudicial. There's video from this incident that is still around. I shared that video on September 10th of 2024 through evidence.com. And so the evidence has been preserved. The evidence is available, witness testimony, video. I would argue that with regard to the delay, there's been no prejudice to the defendant and being able to defend himself against this case. And for those reasons, Judge, I would ask that you also deny his plea and bar with respect to the allegation that the defendant's constitutional right to right to a speedy trial under the US Constitution has been violated.
All right. Defense.
Yes, Judge, thank you. I'll take the arguments in the order that we've done them. So I'll refer to the accusation issue first and then come back to the speedy issue. Judge, it sounds like Garrison is a brand new case, so we'll have to parse that as we may. I have a number of cases in my brief that explain that when when an accusation is filed outside the statute of limitations, that it does in fact have to be listed and explained on the face of the accusation, because otherwise a jury has no way, or a judge has no way to discern whether this is a minute accusation, whether this is an untimely accusation, whether this was something that falls under a null pros and reaccusation, whatever the various exceptions that we may have that do exist. And there are several of them statutory wise, OCGA 1732, 1732.1, 2.2. All of these list various ways in which an accusation can be brought outside the statute of limitations. But what they have in common is that you have to be able to show on the accusation so that the parties reviewing it know, here's why this date stamp is different from what would be considered within the statute of limitations. Now, from a factual perspective, addressing what we discussed here, I know that Madam Prosecutor made a sort of a big deal that there's no signature date and that there's never a signature date. And we've been doing this for hundreds of thousands of accusations with no signature date. The problem is that's actually part of the issue we have here. Because if there was a signature date on the first accusation and the second accusation was just merely a discovery stamp, we would know that because we would have the original date that it was signed and filed on the face. But we don't have that. As the clerk testified, there is nothing on the face of these accusations that's going to let a party know that 1/23/23 stamp date is just a discovery stamp date. It's a date that doesn't really matter because we didn't really mean to file it that way. I mean, there's nothing on the face of the accusation that indicates that. Our clerk also testified that the two accusations that were filed under the discovery, I guess, they were actually filed separately. That each of the accusations was file stamped independently, and then the discovery, the 21 pages of discovery, was stamped as a separate entry. So again, when we look at this, this wasn't one big packet that all got stamped together. The accusations were filed and then the discovery was filed. So again, on the face of the accusation, what we're stuck with here is date stamps that are out of time. Certainly, I can't argue that the body of the accusation is not the same, but Judge, I don't bring the accusations. My client doesn't bring the accusations. What we have is an accusation that shows on its face that it was file stamped and accepted by the clerk on 1/23/23, which is outside the statute of limitations. Now, whether I understand the argument that it was a discovery stamp, but there's nothing that tells us that. And so whether this was an amended, not amended, whether this was refiled for some reason unknown to us, we have no way of knowing because none of that is alleged, explained, or otherwise apparent on the face of the accusation. Judge, and that's where we get into some of these arguments. First point to Bargy v. State, which is 334 Georgia App 409. It's a 2015 case, and it talks about that statute of limitations can be brought both by plea and bar and also as a jury question, and that as a jury question in particular, the state bears the burden of proving the element of the offense, including the statute of limitations. And so where we have this stamped document that has no other indication on its face that it is, that it's just a discovery stamp, we have a jury that's not going to know the difference here. My client and I have no way, just looking at the document, of knowing that either. Judge, and there's also State v. Tasman, which is 145 Georgia App 481, which is a 1978 case, very old case, that basically says that placing the burden of statute of limitations at the defendant's feet is basically impermissible burden shifting, Judge. And so we've got an issue there. We go on to Moss v. State, which is 220 Georgia App 150, and Hollingsworth, which it was citing Hollingsworth v. State within its body, that failure to list exceptions in the charging document renders any evidence of an exception to the statute of limitations inadmissible, thereby leaving the state incapable of proving that an exception applies. And Judge, I'm not going to bore you by just reading my brief to you, but we go on to cite several other cases in that same vein that basically argue that it is incumbent upon the state when we have a subsequently filed document that has nothing on its face showing us that it is not intended to be some sort of superseding or subsequent accusation, to show that it was timely filed and how it was timely filed, Judge. And that's the problem we have here. And I believe, from what I understand of the Garrison case, I believe it actually creates that highlighted problem, because again, how are we to know from the face of the document that it was timely filed? Even if we're alleging the COVID pandemic as the reason for it, we don't know that. I suppose our Supreme Court dealt with that, but I personally, I think I would disagree with that reasoning, because it creates the exact problem that those other cases I've cited sought to address, which is that when we have a file stamp document with nothing else on its face to indicate that it's not some sort of exception or some sort of discovery only or whatever it may be, what we're stuck with is an indictment or an accusation that appears on its face to be untimely. And so that's our issue there. And that's why we raise that issue now, Judge. As to the constitutional speedy trial issue, Judge, I agree. At the time of his arrest, we were under a judicial emergency order. We were dealing with COVID. The issue we have is that the judicial emergency order ended June 30th of 2021. So June 30th, 2021 was the last day that we had a judicial emergency order. So as we stand here in September of 2024, Judge, we're close to 3.5 years post end of the pandemic, at least according to the judicial restrictions on our ability to handle cases. So we go forward from that point. We have an accusation that was filed 11/16 of 21. Judge, I don't argue that that's untimely. It is clearly on its face, and that's part of the issue, right? Is on its face, the 11/16 appears to be timely. And so we move on from there. We have a 2/15 of 22. Sorry, Judge, I'm getting ahead of myself. 2/15/22, we file our waiver. We demand a jury trial. So, Judge, at that point, not only does my client demand a jury trial by filing the bind over and requesting a jury trial, he then files a waiver of arraignment that contains within it an additional demand for a jury trial. And Judge, at the time that was filed in February of 22, we're past the pandemic. We're no longer under judicial emergency order at that point. Judge, and at that point, the case basically goes dormant for 11 months. It's not till January 23rd of 2023 that we have the accusation that we're, contesting as an issue here. We have the second accusation that gets file stamped, and then we also have the discovery served. So we're 11 months past the demand for jury trial before discovery gets served. And then basically, Judge, the case kind of goes dormant again. We're never placed on a trial calendar. We're never placed on a motions calendar, never placed on a status calendar, until the case at some point is transferred to ORCA, and on May 1st of 2024. So now, Judge, almost, what are we looking at here? Almost 3 years after the pandemic ends, we're placed on a status calendar, not even a trial calendar, Judge, just a status calendar at that point, where we basically indicated that we needed to be set over for motions. Motions were set down for today, and here we are, Judge, and we filed the plea and bar in the interim. So, Judge, basically, we have 4.5 years since his arrest to today. But even, I think, more relevant is we have almost 3.5 years since the case was first transferred to State Court of Fulton County. And Judge, given that the pandemic ended on 6/30 of 21, we go to 22 to 23 to 24. We're just short of 3.5 years since the pandemic ended. So I don't think that the pandemic can be laid at the feet of a 3+ year delay after it ended. As the reason why we're standing here today, 4.5 years post arrest. Judge, I want to point out this leave of absence issue, I think, is a bit of a red herring, because we've never been on a published trial calendar. Judge, if we've been on a published trial calendar and I asserted a leave of absence as a reason for a continuance, then certainly that could be attributed to my client. But when we've never been placed on a published trial calendar, the fact that I have a leave of absence filed has no bearing on the calculation of the delay. And so, Judge, I'll turn now to I'll take the Barker and Doggett factors as they come, Judge. I think as your honor is probably well aware at this point, the first hurdle is the delay presumptively prejudicial, and it's been well established that delays, approaching or more than a year are presumptively prejudicial. And at that point, we then get into the balancing factors. Judge, at 4.5 years, we're well past the year point. So we move forward and we start analyzing the 4 factors. First factor, length of delay. Again, Judge, we're at 4.5 years, but even if we take the judicial emergency into play, if we acknowledge that for what it is, that ended 6/30/21, and we're now in September of 24, Judge. We are well outside of the delay being at issue here. And again, Judge, as I said, since we've never been on a published trial calendar, we've never asked for continuance. My leave has never come into conflict with a published trial calendar. So I don't believe that delay can be laid at our feet or at my client's feet. Secondly, Judge, and I think I point this out later in my brief, but just addressing that particular issue, we look at Grizzard v. State, which is 688 Southeast 2nd 408, which quotes Barker, which is, of course, the Barker factors. It says, Barker soundly rejected the concept that a defendant who fails, sorry, Judge, I got ahead of myself. I'm quoting the wrong section, and I apologize to Your Honor. I'll come back to that. I'm trying to find the exact quote because I don't want to misquote it to the court, Judge, but essentially, I believe it was the Grizzard case. It might have been another, and I'll correct the record if I need to, that said, a defendant has no ability or duty to bring himself to trial. The duty to bring the defendant to trial rests upon the state and the court. It's also been discussed and held that where a delay can be attributable not necessarily to the defense or not necessarily to the state, but maybe to the court for whatever reason due to crowded calendars or things of that nature, that it says, nevertheless, it may be a more neutral reason that it might be attributable more to the courts than to the state per se. Nevertheless, that factor must be imputed to the state because, again, the defendant has no ability to bring himself to trial. It may be less prejudicial to the state, but it is not zero prejudice. And that factor has been held against the state in that manner. So secondly, we look at reason for the delay, Judge. Judge, at every opportunity, my client has taken the chance to move the case along. When he was allowed to bind it over, he bound it over. When he waived arraignment and demanded jury trial, he did that immediately, demanded the jury trial. And at that point, that's where the case kind of goes silent for extended periods of time, almost a year before discovery is served, almost a year after that before we're put on a status calendar. And so there's simply no way, in my opinion, to lay those delays at my client's feet. The only place we can place them is on the state or on the court, which again, as has been held, even if placing it on the court is less prejudicial, it is still imputed to the state for purposes of balancing. And I already touched on the leave of absence stuff, Judge. Third factor, assertion of the right. Clearly, Judge, we did not assert a constitutional speedy, I meant a statutory speedy, Judge. But we did assert our right to a jury trial in a timely manner. While it was not phrased as a constitutional speedy trial, the assertion of the right to trial and the not being placed on a trial calendar, Judge, those can't be laid at my client's feet in terms of not being placed on a calendar. And fourth factor, prejudice. Judge, when we look at prejudice, it's not simply that the officers are still around and we have a video. Judge, in this case, there were a number of civilian witnesses who would come into play here. But the problem is those witnesses are now 4.5 years along the line. These aren't professional officers. They didn't write reports. We have no idea what their memory is going to be at this point. We have no idea if we can even find some of them at this point. Judge, basically, to get very minorly into the facts, this case, this issue occurred on a commercial work site. And so we had safety officers, we had flaggers, we had coworkers who were all present with him that day when this happened. And we don't know, A, if we can even find those people at this point, and B, what their memories may be at this point. So certainly there's prejudice there. Further, Judge, Mr. Maxey here had to serve a 12-month license suspension due to this arrest, and he had no access to the courts to try to remedy that at any point. The judge, he's continued to have to live with this case hanging over his head for almost 4.5 years now, which causes, countless amounts of stress and everything else to him, never knowing when or if or how this case is going to come to trial or be resolved. And so, Judge, when we start looking at all of that, we go to Grizzard, Judge, again, which is the case I cited earlier, 688 Southeast 2nd at 407, says, in evaluating the Barker-Doggett factors, we consider 3 interests which the speedy trial right is designed to protect: preventing oppressive pretrial incarceration, which we admit is not at play here; minimizing anxiety and concern of the defendant, which is absolutely at play here. And it goes on to say, most importantly, limiting the possibility that the defense will be impaired. And Judge, given the number of civilian witnesses in this case, I think that factor is absolutely in play. Not to mention, as I said, Judge, the fact that he lost his license for 12 months with no way to remedy it because he had no access to the court to do so. So, Judge, as we start to analyze all of this together, what we look at here is that really the only factor that I think can be affirmatively laid at Mr. Maxey's feet was the failure to actually formally assert a speedy trial right. But again, in Grizzard, the Supreme Court in Barker was quite clear that a defendant has no duty to bring himself to trial. The state has that duty, as well as the duty of ensuring that the trial is consistent with due process. Moreover, society has a particular interest in bringing swift prosecutions, and society's representatives are the ones who must protect that interest. And goes on to state, Barker soundly rejected the concept that a defendant who fails to demand a speedy trial forever waives his right. The Supreme Court reasoned that presuming waiver of a fundamental right from inaction is inconsistent with this court's pronouncements on waiver of constitutional rights, which requires an intentional relinquishment or abandonment of a known right or privilege, indulging every reasonable presumption against waiver. And that's Grizzard again, Judge. Further, as I sort of touched on, Judge, prejudice is the one that we sort of have to look the most at. And given the numerous delays in this case, even after the judicial emergency ended, there's simply no way that we can lay prejudice against my client in this matter, given, again, the loss of license, the civilian witness issues, all of that, Judge. I think the prejudice has to be imputed to the state on that factor. And so for all of those reasons, we are requesting that Your Honor grant the plea in bar.
May I respond to just a few brief points that he made, and then I'll leave it, and I'm certain he can have the last word. It's his motion.
Okay.
But I heard him say that there was nothing to indicate, well, on the face of that January 2023 accusation, that it was not intended to be superseding. And while, yes, there's nothing on the face of the accusation, there is the court record of which you may take judicial notice. It clearly shows that it was filed under discovery. It is labeled as discovery in Odyssey. And so it's our argument that that January filed accusation, that was stamp filed January, but it's not a filed accusation, that would never be presented to a jury. The jury and the state would be proceeding on the November accusation. And that is what would be presented to the jury. And that is clearly within the statute of limitations. So the record tells us that those accusations were not intended to be superseding. I heard him speak to, no harm or prejudice to that factor of harm or prejudice to the defendant, but there's been absolutely no testimony from the defendant about any stress that he has been under as a result of this case. Yes, there is some anxiety or stress that is normally associated with having a pending criminal case, but the case law in Barker is clear that that is not enough to satisfy that particular factor, just the normal stress and anxiety that would come with a criminal matter that every defendant experiences. And he's not asserted anything in the way of stress or anxiety that is unusual or outside of what would normally come with a criminal case. Finally, with respect to the witnesses, the lay witnesses that are alleged to have been on scene and witnessed this incident, I would ask the court who was in a better position to get those witnesses, Judge. Defense counsel has been on this case since it was bounded over from municipal court back in 2021. So to, somehow state that those witnesses are lost when defense counsel and the defendant himself was in the best position to gather information about what sounds like our defense witnesses. Well, that's on them, Judge. The state certainly could not be aware of these witnesses that existed, back in 2020 when we didn't even get the case until 2021, a year after. And so I would argue that they are in the best position to have located and gotten those witnesses, if those witnesses are individuals that, they intend to present as evidence at a trial. And so I'll leave it at that, Judge.
All right, thank you.
And Judge, just a brief response there. First off, Judge, we've been on no trial calendar to try to subpoena those witnesses too. If we were on a trial calendar, then we would certainly have a date certain to serve a subpoena on them. We can't serve them with an open-ended subpoena that says, hey, you're on call for the next 4 years while we wait to see when we show up. Judge, I think Your Honor is well aware that's just not how subpoenas work. Secondly, Judge, many of these witnesses are mentioned in the discovery, not always by name in terms of like, here's their name, their address, their birth date, and their phone number that's required to be served by a witness list, but their existence is acknowledged within the discovery itself, Judge. And finally, even if we are able to track them down at this point, again, part of the issue is not just tracking them down and getting them under subpoena, it's whether their memories have been impaired by the 4.5-year passage of time that we're dealing with here. And I think that is more so to the prejudice of my client than just the sheer fact that we may or may not be able to find them. And Judge, again, we're not required to serve, our witness list until just before trial. Now, I would not do that if we actually knew a trial was upcoming. I always endeavor to do so in a timely manner, but without a trial date, we have nothing to subpoena them to. And so, Judge, I argue that factor should be weighed in my client's favor.
All right. 2 things I need. Tell me again the bind over date.
Yes, Judge, it was 5/25 of 21.
And then state you're going to get me a copy of the Garrison case that was just published.
Yes, Judge, I can email
Okay.
that to you, defense counsel now.
And then making sure I'm clear, defense, you're asserting the constitutional speedy. Is that correct?
Yes, Judge.
And if each of you could submit draft orders to me or to Miss Miller, and I'm gonna probably have to put you under the gun a little bit. I mean Smith. I gave you a new last name. S and Smith. Wow. I would say tomorrow by Monday because I want to wrap it up and give a decision before the end of the month, which is next week. Or so, give or take.
Judge, I have no objection to that timeline, but I want to speak on behalf of the state.
I know, state, I know you guys are swamped. Can we do it, say, by Tuesday? Which is the 24th? And then I can rule real quick on it and.
Judge, I can try my very best.
I know.
If I'm not, I can certainly, request more time maybe, and you can consider that, but I'll try my very, very best.
Let's say Wednesday, the 25th, to get a draft order to me so that, I can do it, say by Friday, the 27th, because we'll be out of time by Tuesday. So I'm trying to get us before we end our ORCA process, unless we have some last minute something that extends it. I don't know. And then I'll consider everything that I've heard and do that. So let's say if everybody can get, or say everybody, the 2 of you can get me drafts by Wednesday, the 25th, and then I can rule by the 27th. Let's see if we can try to meet that. Okay, we can do our best. Thank you. All right, I'll take it into consideration.
Thank you, Judge.
All right, thank you. Yes, you may. Thank you. Miss Lucia?
Hello, Your Honor.
Hello.
Yeah.
Yeah. She's Jake.
Es que se fue el-
Thank you. All right. All right. And Judge, is your email just the regina.mincy@fultoncountyga.gov?
Yeah.
Razón de por qué van a adelantar el pago. Yo voy a responder, ¿ok?
John, I have a quick announcement.
Yes,
I am not sure of the position.
okay.
Division 8.
8, okay.
You're 9 AM. There,
That's Thompson?
yes, either going back to the division,
Yes.
okay.
Yes, return. I thought I recognized you, but you look like a little kid today. I was like, she looks familiar. Yes, Attorney Watson Cafe, yes, that one is returning back to the division, because I know we won't have time to get anything done in a week. Yes. Thank you. Yes, you may. Thank you. Good to see you again. It's been a while.
Bye.
Yes. All right, we're going to take up position 2. Domingo, is it Jarquin?
Harking, Judge.
Huh? Say that again.
Harking.
Harking. Gotcha. J is pronounced with an H.
Yes.
Okay. Let me try to remember that. All right, this is 21 CR 003060G. There are 4 charges and looks like DUI, under the influence of alcohol and hit and run and expired or no license. For summation, offense date June 22nd, 2021, and this is a motion for continuance. Was that too much of a mouthful, Ms. Lucia?
No,
You
that's
can
fine,
get
Your
it.
Honor. No
Okay.
worries. Se llama al estrado el caso 21 CR 003060G. Es la fiscalía en contra del señor Domingo Jarquín. Tiene 4 acusaciones. Una es conducir bajo la influencia de alcohol. La otra es igual, conducir bajo la influencia de alcohol, menos seguro, golpear y fuga. Deber del conductor de detenerse o regresar a la escena de un accidente y licencia vencida o sin licencia en la persona. Esto ocurrió el 22 de junio del 2021 y esta audiencia es para escuchar una moción para continuar el caso.
All right, and the motion for continuance was filed by the defense?
No, Judge.
Oh, I got it backward, by the state.
Yes.
All right, we'll let the state go first.
Yes, Judge. So with respect to this case, Your Honor, the defense has filed a couple of motions in this case. Originally, they filed motions back
Can you
Yeah.
docket on this one?
November of 2021. Those were unparticularized. They later particularized motions after a motions hearing in the division courtroom where the case was continued on August 9th of 2022. And then again more recently on April 30th of 2024. And the amended motions seek to challenge the defendant's performance on the field sobriety evaluation, specifically how he performed them, and then also to the voluntariness of his consent to those field sobriety evaluations. And based on that, within the motion, defense alleges that it was the language barrier as the reason for their challenge to the voluntariness and the defendant's ability to perform these field sobriety evaluations. Based on that, the state then, based on the amended motion, had to make the determination that the language line interpreter that was used by the officer when he administered field sobriety evaluations to the defendant is a necessary and material witness, specifically because their amended motions, their new motions allege the language barrier as a reason for why those field sobriety evaluations were not voluntary. And so then we have to go about getting that interpreter into court, obviously in order to testify as to what it was that was translated, how it was translated, whether it was word for word, whether or not the defendant, had any questions, sought any clarification, all of those things that would go towards voluntariness, whether he understood what was being said to him, all of those things.
Your
And-
Honor.
Hold on 1 second.
Oh, I apologize. I'm so sorry.
And
That's
all
okay.
of
May
us,
this be a good pause
Yes.
for state. Thank you so much.
you should have jumped in sooner. And I know you there, but I forget you there. So I apologize too, Ms. Lucy.
That's okay, Your Honor. I do take notes, but sometimes my hand does not get as fast as I would like it to be. But I have everything thus far. Okay.
Okay. Okay.
Primero para esta moción, si es ya que es de la fiscalía, ellos van primero y la fiscal dice que la abogada defensora ingresó 2 mociones. Una fue en noviembre del 2021 con ningún dato en particular. Luego esa fue a una audiencia el 9 de agosto del 2022 en el cual le dieron una continuación. Eso quiere decir, o sea, que le dieron una nueva fecha. La moción más reciente fue el 30 de abril del 2024, en las cuales fueron mociones que fueron cambiadas o arregladas, en la cual la abogada defensora está alegando y está pidiendo que se evalúe la evaluación de sobriedad que le hicieron el día del arresto, particularmente en cómo fue administrada esta evaluación y si es que usted dio un consentimiento o cómo fue adquirido el consentimiento para la evaluación. La defensa, usted alega que por la barrera del idioma, quizás no fue voluntario este consentimiento. Entonces, ¿cómo para hablar de eso, el Estado, la Fiscalía, debe determinar y debe hablar con el intérprete que fue usado en la línea de idiomas, en inglés se llama language line, en la línea de idiomas que el intérprete que fue usado para explicarle a usted y para traducirle a usted ese día? Ese intérprete debe ser un testigo, debe ser llamado como testigo a el tribunal para que se determine, la juez determine qué palabras fueron usadas, si fue la interpretación hecha palabra por palabra, si es que fue entendible la interpretación y todos esos hechos para determinar con la voluntad, si es que usted dio esa evaluación bajo su voluntad. Go ahead.
And so, Your Honor, the state obviously, in response to those amended motions, had to begin the process of locating the interpreter for this case. Now, of course, we start with the police report. From my review, it does not appear anywhere where the name of this individual is listed. All it says is that there was a language line interpreter that was used. So I then go to the body cam, which gives us some indication of where to start. So the name of the interpreter is Patrick. I have his, ID number, and all of that information, but I've got a first name and an ID number. And so we are just requesting a continuance for the simple fact that we're trying to locate the interpreter so that we can respond to, in a motion hearing, what has been filed by defense counsel, if that is in fact their assertion that a language barrier was the reason why the defendant did not voluntarily consent to these field sobriety evaluations. We need the interpreter to do that. And so that's the reason for the request for continuance, Judge.
All right.
La fiscalía, entonces, para poder responder estas mociones ingresadas al tribunal por usted, necesita ubicar y localizar al intérprete que sirvió de intérprete para usted el día de esa noche. Para hacer eso, ellos se fueron al reporte de la policía. No pudieron encontrar un nombre del intérprete ahí, entonces la fiscalía evaluó y revisó las cámaras de cuerpo, las cámaras que llevan los policías en su cuerpo. De ahí determinaron el nombre del intérprete, el primer nombre, que se llama Patrick, con un número de identificación. Entonces, la razón por la cual la fiscalía está pidiendo el día de hoy una moción para continuar, eso quiere decir para tener una nueva fecha para esta audiencia, es para poder ubicar al intérprete para que él nos dé las respuestas y para que él nos dé la información para nosotros responder a la moción que está presentando la defensa para asegurarnos en cuanto a si es que fue voluntaria o no voluntaria, con conocimiento o no conocimiento de todos los aspectos para la evaluación de sobriedad el día del incidente.
And for Judge, I'll just say, just in conclusion, that this continuance is not sought for purposes of delay. It is merely for purposes of being able to move forward with the motions hearing, which the defense themselves have requested.
Y para concluir, su señoría, esta petición, esta moción no está siendo ingresada al tribunal con el propósito de demorar las audiencias, sino con el propósito de obtener la información y las pruebas para poder contestar las mociones ingresadas por la defensa que ellos en sí iniciaron.
All right. And go ahead, counsel, on and let me make sure I understand. I'm not looking at the docket at the moment. I'm gonna let her print it for me. And do I understand that the particularized motions were filed in 2022 and 2024, or correct me?
Judge, I was about to go into
Good,
that.
okay, we're
Sorry.
okay,
I want
go ahead.
to, since this case is over 3 to 4 years old now, I do want to go on the record and clarify how exactly this case went about. So we filed a waiver of arraignment on 11/17/2021. And so we did file a motion to suppress, a preliminary motion to suppress on 11/17/2021. That's 10 days after our waiver arraignment. Reason we did that was to basically preserve our right to file a later particularized motion once we received full discovery from the state, which we had not at that time. We then did receive discovery that was filed on 7/28/2022. Let's see. Oh, the certificate of discovery, sorry. The certificate of discovery was filed on 11/29/2021, and then an amended discovery was with supplemental information. I think that was video in this case. We did not have video at that time.
Your Honor,
was
I'm sorry
provided.
to interrupt.
Oh,
Your
okay.
Honor, if
That was
defense
a
counsel can
mouthful.
also pause,
There's not.
especially because there's a lot to write down with dates and all.
Okay.
So I'm going to ask you to please go back to the second date that you noticed. I missed that. I understand that since the case is 3 to 4 years old, you are going to go through the record of how the case happened. You began with a date of 11/17/2021 for the waiver of arraignment. What came after that? Can you repeat that, please, for the interpreter?
So let's see. The waiver arraignment was on 11/17/2021. The preliminary motion to suppress was filed on 11/17/2021. And I'm just using numbers for easiness of the case.
Okay, I can catch up now. Su señoría, y esta es su abogada hablando, su señoría, este caso es más o menos, tiene 3 o 4 años, es 3 o 4 años viejos. Lo que quiero hacer ahorita es explicarle el récord del caso, los pasos que han sido tomados en el caso. El primer paso que tomamos, que fue el renunciar a a que le pongan los cargos presencialmente. Eso ocurrió el 17 de noviembre del 2021. Luego, 10 días después, se inició, la defensa entregó una moción preliminar para suprimir cierta información. Después de eso, el 29 de noviembre del 2021, la Fiscalía presentó un certificado de interrogatorios de descubrimiento, la cual fue suplementada y en parte cambiada el 28 de julio del 2022, cuando fue nuevamente ingresado estos interrogatorios de descubrimiento al tribunal. Go ahead, ma'am.
Yes, I just want to make sure I am at the right place. The motion to suppress. 2022, gotcha. Okay, so to recap, we then get supplemental discovery in the form of video footage on 7/28/2022. Mr. Kazuma has a conversation with the state. At that time, it was a Miss Courtney Salette for the state. I believe she's no longer with their office now, but based on that conversation, Mr. Kazuma and Mr. Salette had agreed to continue the motion state that had been set for 8/22/2022 to hear the original motion. Because we had not particularized the motion yet because we were still missing that discovery. And two, the state had actually had unavailability of their witness at that time. So even if we were
Okay.
to go forward.
That's a good place. Nuevamente, para resumir, entonces, el 28 de julio del 2022 recibimos los interrogatorios suplementales con un video. Luego, el señor Kazuma tuvo una conversación con la señorita Courtney Salette, que era de la fiscalía en ese entonces, y tuvieron una conversación en la que estuvieron de acuerdo para mover la fecha, para continuar a una siguiente fecha de calendario de mociones. Esta conversación para la fecha del 22 de agosto del 2022, para que estas mociones sean evaluadas y presentadas en frente del tribunal. Go ahead, ma'am.
And then after that, we're able to file a particularized motion to suppress on the evidence that we did have. That motion to suppress was filed on, let's see, sorry. That particularized motion to suppress was filed on 8/9/2022. So this is our first particularized motion.
De ahí, después de eso, nosotros ingresamos una moción para suprimir la evidencia que teníamos hasta ese entonces. Esta moción fue ingresada el 9 de agosto del 2022.
In that motion, and I apologize, I don't have a copy of it at this moment. I thought I did, but in that filed motion on paragraph 11, we do contend that the state has a burden of proving when relying on the consent exception to the warrant required, that they need to prove that my client acted freely and voluntarily under the totality of the circumstances.
En la página, en esa moción, y disculpe que no tengo esa moción conmigo, pero en el párrafo 11 de esa moción, estamos nosotros diciendo que el requisito de la excepción de consentimiento debe ser adquirido voluntariamente. En ese párrafo, en esa moción, nosotros indicamos eso ya.
That motion also makes an assertion that the officer did not follow recognized scientific procedure under the Harper standard. Now,
esa moción también indica que el agente de policía no siguió los pasos recomendados y autorizados por la regla de Harper.
Now, 2 points on this. One, we know that Harper is not the current standard that we use in Georgia. That has now since been changed to Dauber.
2 puntos sobre esto. Sabemos que Harper ya no es el estándar reconocido y usado en el estado de Georgia. Ahora usamos Dover.
Secondly, Cooper v. State and also State v. Williams were commonly used to assert the totality of the consent argument before State v. Ortiz, which was a 2020 case heard at that time.
También la segunda parte es los casos de Cooper versus el Estado y del Estado versus William, en los cuales indican que debe ser obtenida el consentimiento total, la totalidad del consentimiento, antes de el otro caso de Estado en contra de Ortiz.
Now, State v. Ortiz is the actual case that points to language barrier being a heavy factor in determining whether a defendant gave total and actual consent.
Ahora, el Estado en contra de Ortiz es el caso en sí que menciona e indica y trae a frente la barrera del lenguaje que debe ser determinada que debe ser determinada en el caso de determinar si la aceptación a la evaluación fue completamente voluntaria.
So we didn't include the issue of a language barrier, not because there didn't exist one, but rather because that wasn't the standard at the time.
Entonces, no incluimos esto sobre la barrera del lenguaje, no porque no estábamos a tiempo, sino porque ese no era el estándar legal en ese entonces.
Now let's fast forward. We're waiting for a new motion state. 2 years go by. We can't.
Ahora, nuevamente estamos, a partir de ese punto, nosotros estamos esperando el nuevo calendario, una nueva audiencia para las mociones, por lo cual transcurren 2 años.
For the record, we did not have a court date yet, but I had recently started at the firm at that time. I had not been here. I had not been in the office before this point.
Para el récord, para que sepa su señoría, no teníamos una fecha hasta ese entonces, pero yo acababa de empezar a trabajar en este bufete de abogados. No tenía yo conocimiento de nada de lo que había sucedido antes.
I took a look at the motion and then saw that there was outdated case law in this motion. And I decided that it would be better to file an amended motion and send that over to Ms. Githiea, who was at that time the ORCA solicitor assigned to this case.
En ese entonces yo me fijé en la moción y vi que habían casos e información de casos fuera de fecha, o sea, ya muy viejos. Entonces lo que hice fue amendar, cambiar y poner más a la presente una nueva moción e ingresarla sin tener una fecha de corte con el señor o la señora Gutiérrez, que era la persona de la fiscalía responsable por los casos de ORCA.
That second particularized motion was filed on the 30th of April of 2024, so April of this year. This motion essentially alleges almost everything that the previous particularized motion alleged, but with the added language of language barrier. Should we have gone to motions back in 2022, most likely the argument that we would have had would have been very similar to the one that we had here.
Si es que esta nueva moción que yo ingresé al tribunal fue el 30 de abril del 2024. En esta es en la que yo menciono nuevamente la barrera del lenguaje con casos más actuales. Entonces, este tema de la barrera del lenguaje estaba en la moción anterior y pudo haber sido aireado en el tribunal mucho antes que yo ingresara mi nueva moción.
And like I said before, Mr. Kazuma Sonoda and Ms. Salet had a lengthy conversation over the phone. There was no indication that the state did not know that there was a language barrier issue or an issue with language line back in 2020 as well.
Y como mencioné, el señor Kosumame y la señora Celet de la Fiscalía habían ya tenido conversaciones con esto. Entonces, no es como que no sabían desde el 2020 que había un problema con la barrera de lenguaje o que eso era algo que nosotros estábamos levantando dudas sobre eso.
And the state has had access to their body cam footage and the investigation report, where they could have seen that there was a language line used at that time.
Y la fiscalía ha tenido acceso a las cámaras de los agentes de policía y a los reportes, entonces ellos no es como que no sabían que fue language line, esta línea de intérpretes usada.
So after April, several motions is scheduled, but it is scheduled in August of that same.
Después de abril se pone la moción en el calendario de mociones para el siguiente agosto.
So that is 3 months since we had filed that last particularized motion.
3 meses después de haber ingresado nosotros la última moción.
The motion is then again rescheduled, not by the state or by the defense counsel, but by election of the court. It looks like it had accidentally been scheduled for a trial week. So they had unilaterally rescheduled that to September 18th.
Esa moción, la audiencia de moción, había sido puesta en el calendario para septiembre 18, pero no fue ni por a petición de la defensa ni a petición de la fiscalía, pero fue hecha unilateralmente y lamentablemente creemos que en esa semana era una semana para calendario de juicios, no para escuchar mociones.
So that is an additional month that the court had afforded the state to prepare for the motion.
Entonces ese fue un mes más que el tribunal le había dado a la fiscalía para que se prepare para la audiencia de mociones.
And then last night at around 4 p.m., we do get that filed notice from this filed motion from the state asking that the court continue their case because they had not been able to get their witness.
Y esa noche, a las 4 de la tarde, que nosotros recibimos notificación de que para la audiencia del día de hoy, la fiscalía ha ingresado una moción para que sea la fecha nuevamente se retrase porque ellos aún no habían podido conseguir a su testigo.
Now, with complete candor, Judge, I do believe this is a witness that the state would need based on the motions we had filed back in April and even the motions that we filed back in 2022. So I do think they are in good faith trying to get a witness that is essential for them arguing this motion.
Ahora, para decir la verdad a su señoría, la defensa está de acuerdo que este testigo es un testigo que es necesario para que la fiscalía pueda argumentar en contra de las mociones que nosotros ingresamos tanto en este abril de este año como el que se ingresó en el 2020.
However, on sheer principle, Your Honor, we are 2 years between motion dates and between these issues. And they've had plenty of time to be able to try to find this interpreter witness.
Ahora, diciendo eso, por otro lado, la fiscalía ha tenido 2 años entre calendarios de mociones para conseguir a este intérprete y traerlo como testigo.
They've had 2 years since our first particularized motion that did say we were attacking the consent to the field sobriety examinations at this time.
Tuvieron hace más de 2 años nuestra primera moción que indicaba que nosotros estábamos atacando el consentimiento dado para la prueba de sobriedad en el campo.
They've had since April of this year since they know that there was an explicit language barrier, as was said in our motions, to know that there may have been a language line issue.
Y han tenido desde abril de este año que nosotros nuevamente introdujimos una nueva moción indicando lo mismo para que ellos pudieran conseguir a esta persona de language line.
And in addition, they had an additional month after the court had afforded them that time due to the scheduling error.
Y debido al error en el calendario, la fiscalía tuvo un mes adicional para prepararse.
Meanwhile, my client, his case has not moved since 2022. He has immigration issues, so he is not above the average person waiting for their court date. He is worried if this charge is actually going to expound on him some kind of significant immigration penalty.
Entonces, este ha sido más del tiempo que ha sido requerido para esto. Mi cliente, mientras tanto, ha tenido que esperar y él tiene casos con inmigración y obviamente teme de que la demora en este caso y pueda resultar en algo adverso para él en sus trámites de inmigración.
Especially now that the law has recently changed of this summer via the signing of Governor Kelp, that an immigration officer can come get him if he is to go to jail for any of his charges.
And Your Honor, I'm just gonna object. I'm not sure what the relevance of that is to a motion for continuance on the basis and the grounds that the state has.
I will get to a point, Your Honor.
Okay. Briefly. Because I do think we're getting a little off subject. I do get the idea, obviously, that, and I understand that you're obviously objecting to the motion for continuance, states asking for continuance, and you're giving me reasons why I guess it's imperative that we go forward without the continuance, correct?
Judge.
Okay, I do understand that.
Y, y lo último que su abogada dijo antes de ser interrumpida fue que es mucho más importante esto de inmigración, dado que el año pasado pasó una nueva ley, el gobernador Kemp en el estado de Georgia, que cualquier persona que fuera a la cárcel puede ser tomada por inmigración. Ahora, en eso, la fiscalía tuvo una objeción y objeta al hecho de que esa información no es relevante al caso por el que estamos aquí o a la moción para continuar, para mover la fecha. Entonces, ahora la juez opinó sobre eso y les va a dar la oportunidad que ambas partes aleguen sobre esa objeción.
And Judge, I'll move it forward that just say that the state had been on notice since 2022, or if in their best case scenario, since April of this year.
Lo que quiero añadir para concluir, su señoría, es que la fiscalía ha estado notificada de esto desde el 2022, en el peor caso de los casos desde abril este año.
And while I do understand that it may be a lengthy process for them to be able to contact this language line interpreter, I do believe that they have had more than enough time to attempt that prior to this date.
Y aunque sí estoy de acuerdo en el hecho de que toma tiempo ubicar al intérprete que trabajaba para Language Line esa noche, también estoy insistiendo en que han tenido suficiente tiempo o bastante tiempo para haber hecho eso y para poder llegar este caso a una audiencia. Your Honor, I'm not sure. I apologize. Your microphones are muted as well. All microphones got muted.
And I apologize that muted everybody.
May I
I'm
repeat-
sorry, counsel.
May I repeat?
Repeat that, yes.
And so I'm trying to remember where I started from.
Sorry about that.
It's okay. And so, Judge, if today the state is not ready to proceed on their motions, I would respectfully ask the court to either grant our motion based on the absence of them being able to actually prove that they fulfilled their burden, or in the alternative, dismiss the case for want of prosecution. He was actually charged with this case, with this charge in 2021. It's been significant time and an undue burden for my client. So with that, I will rest my case.
All right.
Lo último,
Go ahead.
Thank you. Entonces, para resumir, su señoría, lo que yo quiero indicar es que la Fiscalía ha estado notificada de esto desde el 2022. Entonces, quisiera pedir una de dos cosas. La primera es que nos acceda, nos confirme nuestra moción para continuar con el caso sin evaluar, o sea, sin dar la moción a la Fiscalía, o la segunda opción, que anule este caso y que quiten todos los cargos, considerando que estos cargos, y esto ocurrió en el 2021, y eso ha sido muchísimo tiempo y es un peso sobre mi cliente, que él no, o sea, un peso no aceptable sobre mi cliente.
All right, State.
Thank you, Judge. I want to first address, the statement that we have had an additional month, when this case was scheduled for a motions hearing in August I'm looking at the record on this case, Judge. This case went from a status conference in May of 2024 to a motions hearing today, September 18th, 2024. Since this case has been in ORCA, it has not been on any prior motions calendar, and I'm looking at the record on that.
Lo primero que yo quiero hacer en contestación es que este caso no ha estado en un calendario anteriormente para mociones. Estuvo en una conferencia para determinar el estado del caso en mayo del 2024 y después de eso se puso en el calendario de mociones del 18 de septiembre, del día de hoy. Entonces, antes de este caso ser parte de ORCA, no ha habido ninguna otra fecha donde se han podido alegar o escuchar las mociones.
The way that the state prepares for these hearings is when we get a published calendar. That is how we know to begin subpoenaing witnesses.
De la forma en la que la Fiscalía se prepara para estos casos se prepara una vez que haya fecha publicada en un calendario de audiencias para el caso. Ahí es cuando empezamos a encontrar o a determinar o a mencionar, comunicar a los testigos.
So there would have been no prior motions hearing prior to today on which the state would have been aware about subpoenaing witnesses for this case.
Entonces, no hubo ni hubiera habido antes del día de hoy una fecha con un calendario de mociones para que la Fiscalía pueda ordenar a testigos que se presenten.
And I caveat that, I qualify that by saying in ORCA. So it is correct, there was a motions hearing that was scheduled on August 3rd.
14th.
13 or no?
So I show August 3rd of 2022, motions before Judicial Officer Judge John Mather, courtroom 2E. That is what I'm showing.
That is the 2022.
Correct. So.
And then the
14th that
motions
you're
one
speaking
from
of,
May
August
1st.
14th, is not in the system. There was no published calendar with this case in August, to my knowledge.
Judge, may I address this single point? Because there's a really easy answer to it.
Or do we have, so what was the August date was the incorrect date?
So
correct?
back in May, when we had a virtual status conference for this case, we were given that verbal date of August 14th, 2024. We then received an email by Miss Felicia Rogers directly to us and CCing the state saying, "Good morning, I'm ready to inform you that your case has been rescheduled from Wednesday, August 14th at either 9 a.m. or 1:30 p.m. to Wednesday, September 18th, 2024 at 9 a.m. This is an official email sent by Ms. Felicia Rogers, Senior Court Associate, Project ORCA.
So, Your Honor, once again, there was no published calendar in August with this case on it, which is the only way that the state knows to begin subpoenaing witnesses. Sounds like there was a verbal announcement of a potential or prospective or tentative motions date made in May for August, and that date never materialized, and instead it was changed to September. So the published calendar was for today. And that's how we knew to begin subpoenaing witnesses for this case, because it was on a published calendar, the one for today.
My turn.
Oh, yes, I'm sorry.
It's okay. Entonces, su abogada de la defensa está alegando que en el día que hubieron fechas para el calendario de mociones anteriores, pero la fiscalía está alegando que esas fechas fueron antes de que este caso entrara a las audiencias de tipo ORCA. Entonces, lo que contesta su abogada defensora diciendo que cuando tuvieron la conferencia de estado del caso, que fue virtual en mayo del 2024, se les dio una fecha verbalmente de agosto 14 del 2024 y después recibieron un correo electrónico de la señora Felicia Rogers, la cual trabaja para el tribunal, indicando que la fecha de la audiencia de mociones va a ser para el día de hoy, septiembre 18 del 2024. Entonces, que fue cambiada la fecha de lo que les habían dicho verbalmente que iba a ser agosto 14 a una fecha ya publicada y por escrita en el calendario de audiencias del septiembre 18 del 2024. A lo cual la fiscalía contesta que la fecha de agosto 14 del 2024 no fue una fecha publicada en un calendario de audiencias en el mes de agosto, fue nada más una fecha nombrada verbalmente como una fecha prospectiva, como una fecha tentativa para la audiencia de mociones, que esa fecha no se materializó, pero que la primera fecha materializada, publicada, fue para el día de hoy, 18 de septiembre. Y entonces es ahí cuando la fiscalía puede empezar a prepararse dando órdenes de que se presenten testigos.
Judge, the state does not subpoena witnesses for a tentative date that is arbitrarily announced verbally in court. We have to await a published calendar. And that's what we have here.
Su señoría, la fiscalía no ordena que se presenten testigos con fechas tentativas o dadas verbalmente. La fiscalía espera a ver una fecha publicada en el calendario de los tribunales para empezar a ordenar testigos que aparezcan.
So I want to be clear that there is no previous motion state here in the ORCA division between today and when they filed their last amended motion that would have notified the state to subpoena its witnesses.
Quiero estar bien clara en este punto. Desde el día en que la defensa ingresó la nueva moción hasta el día de hoy, bajo el sistema de ORCA, no ha existido ninguna fecha previa para una audiencia de mociones.
The last motions date, scheduled motions hearing for this case was on August 3rd of 2022 before Judge Mather.
La última fecha en la que hubo en un calendario, este caso llegó a un calendario de mociones, fue bajo el juez Mather el 3 de agosto del 2022.
That case was continued. Defense counsel is correct that case was continued, as is noted in our system.
La abogada defensora tiene razón que en esa fecha ese caso fue continuado, o sea, fue movido más adelante a fechas futuras, como está en nuestro sistema indicado.
Defense counsel states that it was a mutual reset because the state's witness was unavailable and because the defense had not particularized their motions.
Como la abogada defensora tiene razón, que en esa fecha, esa continuación que se dio fue de forma y aceptación mutua entre ambas partes. Por un lado, porque las mociones entregadas por los abogados defensores no daban particularmente motivos para la moción, y también porque la fiscalía no tenía en ese entonces el testigo.
Your Honor, we don't know what state witness was unavailable at that time. There has been, oh, go ahead.
Sí, su señoría, nosotros no sabemos cuál testigo de la fiscalía no estaba disponible en ese entonces.
We don't know what witness was unavailable at that time. And I would venture to say that the state would not have known even at that time what witnesses to subpoena because the motion was completely and totally unparticularized and did not put the state on notice.
Además, yo podría alegar, su señoría, que en esa fecha, porque la defensa, las mociones de la defensa no tenían datos particulares, no hubo notificación particular a la fiscalía, entonces la fiscalía no hubiera sabido a esa fecha qué testigos citar y obligar a que se presenten.
But by defense counsel's own admission, the motion did not assert anything about a language barrier. That was not asserted until April 30th of this year.
Y con las palabras de la defensa, usando las palabras de la defensa de una barrera de idioma no fue acertada sino hasta abril de este año. No fue completamente acertada en las mociones iniciales de hace 2 años.
I think certainly the case was reset for defense to particularize their motion because they in fact filed a motion to suppress that was particularized with facts on August 9th, 2022, just 6 days after the first motions hearing before Judge Mailer.
Y yo pienso que, y le presento a su señoría, que esa audiencia de mociones fue continuada a una nueva fecha, particularmente para la defensa, para que la defensa pueda indicar particularmente las diferentes defensas que estaban ellos alegando, porque eso fue ingresado a la corte el 9 de agosto del 2022, únicamente 6 días después de la audiencia de mociones con el juez Mader, que se hubiera llevado a cabo.
As defense counsel stated, she then amended the motion on April 30th of this year in order to add that challenge regarding the language barrier.
Como la abogada defensora lo indicó, ella cambió y añadió cosas a la moción el 30 de abril de este año para añadir la defensa de una barrera de lenguaje.
So that is the first opportunity that the state has been placed on notice that this interpreter would in fact be needed for a motions hearing.
Entonces esa fue la primera ocasión, la primera vez en que la fiscalía fue notificada de que iban a necesitar a este intérprete como testigo.
And so, Judge, the officers obviously are available. They're still with Roswell Police Department.
Entonces, su señoría, los agentes de policía están disponibles. Ellos están con el Departamento de Policía de Roswell.
So we know where they are.
Sabemos dónde están.
They were placed on call for today.
Y ellos se pusieron tentativamente dispuestos a venir el día de hoy.
But if defense is going to proceed with a challenge based on a language barrier, the state has to have that interpreter present.
Pero si la fiscalía, si la defensa va a insistir para usar la defensa de una barrera de lenguaje, la fiscalía necesita tener a ese intérprete de testigo presente.
And so the motion for continuance is to secure that particular witness, not some other witness that may have been unavailable back in August of 2022 that we don't know of.
Entonces, la moción para continuar a una siguiente fecha del día de hoy de la fiscalía no es únicamente para poder obtener y ordenar ese testigo aquí en la audiencia, no por ningún otro testigo que en el pasado, o sea, sea parte de esto o se pueda presentar.
I do appreciate that defense counsel recognizes that this motion has been brought in good faith by the state.
Y aprecio que la abogada defensora ha admitido que esta moción ha sido ingresada de buena fe por la fiscalía.
But this interpreter is a material witness, and we are asking that you grant the state's motion for continuance in order to procure their testimony.
Este intérprete es un testigo material y le estamos pidiendo, la fiscalía le pide a su señoría que nos dé esta moción para una nueva fecha para poder tener presente al intérprete.
Your Honor, I don't think that just blanketly granting their motion in whole or in part is appropriate, nor is dismissing the case for one of prosecution.
Su señoría, no pienso que el darles a ellos, a la defensa, la moción de ellos, en aceptar la moción de ellos, está bien, ni tampoco pienso que está bien que se anulen los cargos, se acabe el caso por falta de persecución del caso.
Neither of those is appropriate for the reason that, as I stated, the state was put on notice that this particular witness was needed when they amended their motion in April.
Y ninguno de las dos opciones que presentó la defensa son viables por el hecho de que la fiscalía fue únicamente notificada de la necesidad de tener a este testigo presencial cuando ingresaron la nueva moción el 30 de abril.
Neither is it appropriate to grant some just blanket granting of the entire motion, because there are some points that we could have proceeded on. I'll let her speak.
Tampoco pienso que sea apropiado darles la moción, fallar a favor de la moción de la defensa, porque hay partes de esa moción que pudieron haber sido aireadas el día de hoy.
There's reasonable articulable suspicion that would not have needed an interpreter to testify.
Hay sospecha razonable, la cual no iba a necesitar un intérprete para testificar.
There's the issue of the implied consent, which I don't believe would have required testimony from the interpreter, because the lack of English just under the law does not render the defendant incapable of refusing the test.
También hay el consentimiento implicado, la regla de consentimiento implicado, bajo la cual nada más el hecho de que el acusado no hable el idioma no le da la razón de negarse a una evaluación de campo.
Your Honor, it is well established that through case law that the officers are not required to read implied consent in any language other than English.
Está por ley dicho que los agentes de policía no necesitan leer consentimiento implicado o las reglas de consentimiento implicado a ninguna persona que ellos detengan en ningún otro idioma aparte del inglés.
And I say all of that to say just that there are other things within the motion that we could have proceeded on that would not have required an interpreter to testify.
Nada más quiero resumir que hubieron otras partes de la moción de la defensa en las cuales nosotros pudimos haber continuado el día de hoy sin necesidad de el intérprete como testigo.
And so I don't think granting the whole motion is appropriate.
Entonces, no, mi opinión es que concederles la moción a la defensa completa no es apropiado.
I also find it fundamentally unfair that defense gets essentially 3 bites at the apple to file a motion to suppress.
Y también quiero decir a su señoría que es fundamentalmente injusto que la defensa tenga 3 oportunidades de ingresar una moción para suprimir.
They have filed 2 amended motions, 3 motions to suppress in total. And the state is requesting its first continuance because the previous one was, I guess, mutual. Admittedly, I wasn't there, it was mutual. But the first continuance to be able to locate this interpreter.
No es razonable porque la defensa ha tenido la oportunidad y ha ingresado 2 mociones cambiadas, 3 mociones para suprimir evidencia, y la primera extensión del plazo de la audiencia fue dada de mutuo acuerdo. Entonces, esta es la primera vez que esta fiscalía está pidiendo una extensión del plazo.
And so I would ask that you grant the state's motion for a continuance so that we can secure the testimony of the interpreter and respond to the latest and most current amended motion that has been filed by defense that asserts this language barrier as a reason that the defendant did not consent to the field sobriety evaluations.
Entonces le pedimos a su señoría que nos dé, que falle a nuestro favor y nos dé esta extensión de tiempo, esta continuación para nosotros poder prepararnos sobre el nuevo, en contra del nuevo, de la nueva alegación sobre la barrera del lenguaje para la prueba de sobriedad de campo.
And so that the state can properly respond to the motions filed.
Y para que la fiscalía pueda responder a estas mociones ingresadas apropiadamente.
Nothing further from the state, Judge.
Eso
All
es
right.
todo de la fiscalía.
May I respond, Judge?
I have the motions. I have heard a lot of oral argument, probably more than most judges would allow on a motion for continuance. So I have to, with all due respect to both parties, and you've made great arguments, go ahead and rule that I'm going to give my ruling so that we don't, I don't go down in history as probably having the longest motion for continuance hearing. And I understand both sides.
Yo entiendo a las 2 personas en este momento, entiendo las 2 partes. En este momento yo tengo las 2 mociones enfrente de mí y he escuchado los argumentos orales y verbales de ambas partes, dándoles mayor tiempo que lo que cualquier otro juez les hubiera dado. Entonces yo estoy lista ahora para dar mi fallo en cuanto a las mociones presentadas el día de hoy.
All right, I'm going to, for several reasons, but I'll be clear in this, and the state can prepare me an order that I'm going to grant the motion for continuance. First of all, because we don't have another ORCA date within which to reset this hearing. So we will have to go back to the division judge. And I think you said it was May 3rd. For that here, I do feel that the motion for continuance should be granted because it appears that from looking at the docket as well, that August, May verbal, but August date having been reset to today, and given the state the time to respond and produce that material witness of the interpreter, now that it is clear what the defense motions and arguments are for, I don't think it's appropriate at this time to dismiss the case, because I don't see, again, as the state has articulated several motions for continuance or request that would have said they're not ready, they failed to produce the material witness because they haven't had a chance to even attempt to produce, it appears, because it has not been clearly set on a motions calendar until today. And generally, we give one, maybe two, continuances for those reasons. And so the state will be on notice now. Once it's rescheduled with Mather, they don't have their material witness here, which now we know is the interpreter from the language line, then obviously your motions to dismiss can be orally made again in court, and the judge can rule on them. We're just in a quagmire right now with ORCA ending in a week or so, and we would not be able to reschedule it if we thought we could. So I want to be fair to both sides so that you can argue this case and argue the particularized motions in the proper fashion, and both parties can have the ample amount of time to prepare as well as bring their material witnesses. All right, so the motion is granted. And state prepare me an order, and that will be the ruling of the court.
Thank you, Judge.
All right, thank you.
Entonces, el fallo de la juez es que les va a dar la moción a la fiscalía para continuar y pueden extender la fecha de la audiencia. La razón principal para este fallo es que no tenemos en este momento otra fecha bajo el sistema de ORCA para darles para una audiencia, un juicio de este caso. Entonces va a necesitar regresar de todas formas al juez de la división, al juez que estuvo antes, que es el juez Mather. Aparentemente la fecha que fue dada para agosto fue una fecha verbal. Eso fue extendido en el calendario para el día de hoy. Entonces el día de hoy es cuando la fiscalía recibe la notificación y se le está dando tiempo hasta la nueva fecha para producir todo lo que necesite el testigo, o sea, para producir el testigo. Además de eso, la jueza no determina que es apropiado el anular y quitar los cargos en este caso, porque la fiscalía no ha tenido tiempo para ordenar o producir al testigo. La fiscalía ahora está notificada, necesita este testigo material, este intérprete de la línea del language line. El sistema de ORCA está finalizando en un par de semanas y la jueza está tratando de ser justos para ambos lados, para que ambas partes puedan regresar preparados con los argumentos y con los testigos.
All right, thank you, Ms. Lucia.
You're welcome, Your Honor, and if that is all you need, may I be dismissed?
Yes, you may. Thank you.
Have a good day.
You too. All right, thank you.
Thank you, Judge.
All right, thanks. And those are all the cases we have. Ms. Smith?
Yes, Your Honor.
All right.